And explain your red eye, would you, Fred?
Oh, thank you very much. Yes, I was up with Dan Kirkbride up in his ranch in Chugwater and wound up with a bit of a coughing attack and popped a blood vessel. And too bad it's not October. I'd be ready for Halloween, but it's pretty embarrassing, I tell you. Fred Von Ahrens, I'm the Vice President of Manufacturing at Genesis Alkali, formerly FMC Corporation, Soda Ash, and Tronamine.
I'm Mitchell Schwab. I have a bit of a background with charter schools. I worked as the Southeast Division Vice President for a charter school management organization in North Carolina for several years, where we expanded the charter school operations in that state. Grew up from 0 to now there's approximately 15,000 students in that network in that area. After I left, I became outside general counsel to a network of charter schools in Arizona, and I'm still actively participating in that field, and as well as a lot of environmental legal aspects when it comes to the sage grouse problems in the state of Wyoming. So that just kind of was thrown on me as well. So
I'm John Masters, recently retired as an attorney. So McKinsey, I told you have to do all the legal work today. It's not Cindy or me, it's you. Prior to that, I practiced law in Cheyenne. I practiced as a commercial and transactional attorney. Prior to that, I was at the WDE, where I started out as the attorney for the superintendent and then became the deputy superintendent. Prior to that, I worked for the foundation of my church in Casper, where I was responsible for remodeling the church diocesan office, and ultimately was involved in managing a lot of their funds. Prior to that, practiced law. Prior to that, I was working for a couple of entrepreneurs that set up a company here in Cheyenne, Safeguard Services, and became involved in insurance and a variety of things with those guys. That was kind of fun. And started off as a lawyer. So prior to law school, I was a CPA. So that gets you back to a lot of years in my life. So.
Well, I'm Joe Filer, and first off, it's just an honor here to be here to serve the state of Wyoming, and more importantly, the students of Wyoming. I graduated from Black Hills University with a bachelor's in education and then earned a master's through Leslie University. I then went on to teach 35 years in career and technical education through the Natrona County School District, primarily the last 25 years in welding and joining. I still stay active with students in education in Wyoming. I serve on the Skills USA board. It's one of our 5 CTSOs, our career and technical service organizations. And I also serve on the WACD board, which is the Wyoming Association of Career and Technical Education. Again, it's an honor to be here and meet, I think, some people with diverse backgrounds, and I'm excited about the opportunity. Thank you.
Good morning, board members. I'm Cindy Delancey. I am currently the president and CEO of the Wyoming Business Alliance, which is different than the Wyoming Business Council. So I just thought I'd get that out there. The Wyoming Business Alliance is Wyoming's premier trade association for the private sector business community. As Mr. Masters mentioned, I too am a practicing attorney. I've been a member of the Wyoming Bar for 20-something years now. Before that, I served as a prosecutor. I was the first woman elected to be the Carbon County and prosecuting attorney. I was a special United States attorney, federal prosecutor on an appointment for many years as well. I too had the pleasure of working in the Attorney General's office, representing the Division of Criminal Investigation and the Crime Lab. So I've had a really wonderful and diverse career here in Wyoming. I'm extremely honored to be selected to be a member of this first board, and charter schools are extremely important to my membership. I helped with this legislation that got us here today. So excited to see where the conversation goes and looking forward to having productive sessions going forward. Thank you.
I like to tell people I'm a native of Wyoming, but that's a lie. And I want to confess that up front. My parents were in Scottsbluff, Nebraska, the day I was born. And it's been a plague on my personality ever since, but hope none of you are from Nebraska. But having lived in LaGrange, in the LaGrange area, all my life, I've had the opportunity to be engaged in agriculture, farming, and ranching. I have some background in the transportation industry, and I have been a classroom teacher, a secondary school principal, and a school district superintendent. In addition, I had the honor of serving Goshen County in the Wyoming legislature for 18 years in the House of Representatives. And I feel it a privilege to be amongst such a distinguished group, and I'm looking forward to working with you.
I'm Janine Bayteski. I just retired for the second time. In December, I finished my 20th year on the school board in Teton County and decided not to seek re-election. My first retirement was as an executive from Ford Motor Company, where I served for 25 years. I feel really passionate about this topic. I think that there is opportunity, but there's risks as well. And I think the important thing for us as we're moving forward is to sort of navigate our way through this and put appropriate processes and procedures in place to eliminate the emotion associated with a lot of the decisions we're going to take. Saying that, you should all know that I have a very strong technical background, so I tend to see things pretty black and white. There's not a lot of gray space for me, so I look forward to working with everybody on the board. Thank you.
Elaine,
Yes,
do we have Dr. Buss on?
he is not on at this time. I think he might be having some technical issues. So thank you for those introductions. And at this time, I would call for any nominations for chairperson for the Wyoming Charter School Authorizing Board.
I would nominate John Masters.
I'll nominate Mitch Schwab.
Hearing no more nominations, nominations has ceased. Is there any discussion?
You want a campaign speech? Is that what you're looking for? Mitch may have one ready. I don't.
Not from me. Not for my benefit, so, okay.
Well, I'll mention something here. I just met Mr. Masters here today, but I was able to work with Mitch on a CTE charter school that was proposed to Natrona County School District. I was impressed with his knowledge and so forth and background in charter schools. And we hadn't met in person. It was all online and so forth. But again, the expertise that he brought to the table and so forth, I was impressed by. I thought he did an excellent job.
I think probably any person on this board could be chairperson and do an excellent job. I nominated John because of his past experience in working on the general educational philosophy of the state of Wyoming. I have confidence in him as an individual. I have not met Mitch, and it's nothing against him at all that I nominated John. I just think John's a man for the job.
I guess I open up to a question. This to me is going to be a challenging first year. Who has the time to do the work?
I think that's a great question. Had this been 4 months ago, I would have said there's no way. But I was the head basketball coach at Star Valley High School this past season. And with a lot of changes in my life, business-wise, law firm-wise, disappointment-wise, I ended up stepping down from the head basketball coaching job. So I think my time has opened up significantly. So I know I can make it. I can make it work. So.
Well, being retired, I found that I have a lot of time now. There are things I like to do, play tennis, being foremost, going to be playing in the governor's tournament. The governor's, it's not his tournament, it's the governor's cup. And, but other than that, and I try to do that pretty regularly, my activities are consumed by taking care of a dog that I just adopted, a laboratory rescue dog, and trying to get my house in order after many years of running around doing things other than keeping my house in order. Doug may have mentioned, I was on the governor's ride committee or advisory board where we discussed the general philosophy of education. And I think that the work of the charter schools could meld very nicely with the recommendations that came from our group. In that capacity, I served with Fred, and Fred was very valuable, as I'm sure all of you will be as we go forward with our work here.
As John said, I was on the ride, and I think John did a wonderful job leading us through that process. And so I would strongly state that I believe he's very qualified. I just met Mitchell, and I need to know if your basketball team beat Rock Springs or Green River's basketball team. That could help sway my vote. But it's good that you have time, and I know that's a wonderful area, and it sounds like we have two very qualified candidates. That's a good problem to have.
I think I better address the basketball situation. The Rock Springs one was very close. It was a close game, but we did win.
Okay, if there's no further discussion, I would, if it's the pleasure board, do a roll call vote on the nominations. Just a second, sorry. Doug Chamberlain,
John Masters.
Cindy Delancey,
Mitchell Schwab.
Joe Filer,
Mitchell Schwab.
John Masters,
John Masters.
Mitchell Schwab,
Mitchell Schwab.
Janine Bayteski, Fred Von Ahrens,
John Masters.
Well, congratulations, John Masters, on being voted the new chair. I will go ahead and turn the meeting over to you.
Thank you. I guess the next order of business is to elect a vice chairman and followed by the election of a secretary. So I would open the nominations for vice chairperson at this time. Don't all stand up and shout at once.
I nominate Janine.
Are there any further nominations?
I'll nominate Mitchell Schwab.
Any further nominations? Well, should we hear again from Mitchell and Janine? Briefly, maybe? Have things changed for you, Mitchell, since? Janine, would you like to tell us something about yourself, or are you satisfied?
I'm pretty satisfied, and I'd be pretty satisfied if Mitchell won as well.
That being said, let's close nominations and vote. Unless, Doug, you had something?
I have a question. Was Mitch a coach or an official or both? No, I love basketball. That's why I asked.
All right, well then, Elaine, if you'd call roll for the vote on the chair, vice chairperson.
Sorry about that. Doug Chamberlain,
Janine,
Cindy Delancey,
Mitchell Schwab,
Joseph Feiler,
Mitchell Schwab.
John Masters,
Janine,
Mitchell Schwab,
They threw my name in the ring. I guess I'll go Mitchell Schwab.
Janine Bateski, Fred Von Ahrens,
Mitchell Schwab.
Mr. Chair, we have a tie.
how's that possible?
Mr. Chair, we have 4 votes for Mitchell Schwab and 3 votes for Janine Bateski.
Congratulations, Mitchell. I look forward to, in my absence, you running a good tight ship. So the next item on the agenda is the election of a secretary to the board. And I would open it at this time for nominations. Janine.
Mr. Chair, may I ask what that means? What are the responsibilities of that job?
Well, at this point, we don't really have any definition around any of these jobs. But I believe that we soon will, and that the secretary will not be the one necessarily keeping and taking notes, but will necessarily be the one that reports on the matters that come before the board, make sure that we stay on the agenda, things of that sort.
Mr. Chairman, question, is the necessity of a secretary included in the legislation, or refresh my memory?
Well, we could ask Mr. McKinsey, but I don't think the legislation gives us any guidance in this area, does it?
It does not. There are no officers specified in this board's enabling legislation.
I guess then my question is, do we need a secretary, or are the duties adequately covered by our chair and vice chair? I guess discussion on that.
So let's put that to the board. Shall we have a secretary? Let's just do this by a show of hands. All in favor of having a secretary, raise your hand. All opposed to having a secretary, raise your hand. Okay, we won't have a secretary. That could change if we ever decide we need one.
that looked like 3-2.
I think that maybe 4-2. So, all right, we won't have a secretary.
And I think that's, Mr. Chairman, if I think that's probably a good starting point.
Sure.
Let's hope that we're
We
able
can-
to manage this, but I'm certainly open that should circumstances change, revisiting that topic.
I guess my big question would go towards the department. If it's more helpful for them, for us to have a secretary, at least with their job duties as it comes to the board, is it more helpful for you or less helpful, or does it make any difference?
Mr. Chair, Mr. Schwab, I'm not sure that it makes a difference at this point, not knowing quite what we're looking at. So, but I'm certainly interested in the idea that you guys mentioned, that if that does become necessary in the future, that could be revisited.
Let's just hold it open. If we ever need a secretary, we'll cross that bridge. The next item on the agenda is the adoption of rules. Is there a motion?
Mr. Chairman, if I could just say something briefly before I make the motion. I think there are a lot of misconceptions about parliamentary procedure. And for instance, in the legislature, we went by Mason's rules. And of course, most organizations that I'm aware of go with some form of Robert's Rules of Order. And I only say that is because my motion is that we use Robert's Rules of Order, but in an abbreviated sense as approved by the board.
Is there a second?
I'll second that motion.
Discussion? I'll ask the question then, in the abbreviated sense, what do you have in mind for that, Doug?
Well, Mr. Chairman, I think apparently we're going to have some committee actions, and I'd be glad to serve on that if somebody would serve with me or two people, and let us go through, Robert, on just the major functions and see what we think will work best for us, and come back with a recommendation to possible amendments to the entire board.
Thank you. Any further discussion? Again, by show of hands, all in favor of the motion, raise your hand. Looks unanimous. So that motion passed. The next item would be additions or changes to this agenda, and you've suggested one already, I think, by suggesting there might be a need for committees, Doug. Do you have any other suggestions, or is that your suggestion, I guess? And maybe I'm opening this to everybody, so if anyone else has suggested change. Shall we put consideration of committees or on the agenda, Doug? Yes. Okay.
Mr. Chair, if I could
Mackenzie.
just offer a point. We haven't gotten to the training about open meetings yet, but this does have some implications in terms of reordering your agenda. That would be fine. Additions, I'm a little more concerned with if it doesn't fit within the scope of something that's already as part of the public notice on the agenda. This meeting would be classified as a special meeting, which is limited to those items that were previously noticed. And because appointment of committees doesn't appear on the agenda, I have a concern about that being outside of that scope. My suggestion would be to add that to the agenda for the next meeting that this board sets.
Okay. So the suggestion is that we table it till the next meeting. And I take that under advisement. Is there any discussion around that suggestion? Right, well, then I'll just use my prerogative to table it. And we'll put that on a future agenda. Are there any other items that we should add to or consider reorganizing our agenda? Because we can move the things around. All right.
Mr. Chairman, that's kind of a good point. I was kind of considering that myself, that I will certainly be looking for guidance on where we can find lunch in 30 minutes in Cheyenne, but however, we need to adjust that when the time is right. I'm sure I defer to your judgment on a break for us.
Mr. Chair, if I may.
Sure.
Ms. Delancey, we do have lunch coming for the board here, and it'll be down here in the.
Okay, well, that solves that. Thank you.
Thank you. Well, the next item then is a discussion with our attorney, Mr. McKenzie. Would you, Mackenzie Williams, Mr. Williams, would you introduce yourself first, and then we can entertain your discussion?
I will. I will bring my presentation up, and then I'll go ahead and sit up there if that's the preference of the board.
That'd be fine.
Normally, I like to walk around, but the room doesn't really lend itself to that, so.
Are all the board members able to see the screens adequately? Okay, thanks.
Thank you, Mr. Chair, members of the board. My name is Mackenzie Williams. I'm with the Attorney General's office, and I'm representing this board as part of my assigned duties. So let me talk a little bit about myself, and I'll explain a little bit more about our office and what we offer as part of the presentation, but just me personally. I graduated from, before law school. I actually worked for several years as a victim's advocate in the domestic violence, sexual assault victims advocacy organization in Laramie. Then I went to law school. From there, I clerked for one justice of the Wyoming Supreme Court and 2 different federal judges. And then at that point, I went to the Wyoming Attorney General's office. So I have been there ever since. That was 2011. So I've been doing this for just shy of 12 years at this point. During my time at the Attorney General's office, I have always represented educational agencies. I have represented the Department of Education, the State Board of Education, as well as the Community College Commission from the beginning of my tenure at the Attorney General's office. Around 2015, I was moved to a different division to become a supervisor. At this point, I and my team represent a broad variety of agencies, including the Secretary of State, the State Loan and Investment Board, many professional licensing boards, lots of other sorts of conflict work. Last time I counted it up, it was about 35 agencies that we took care of. So a pretty broad swath. One of the things that experience does lend me is that I do have the opportunity to observe lots of different Wyoming boards and see how they work. And I'm happy to share that experience as a practical matter if you ever are interested in knowing any of that during the course of your own duties. So unless there are any questions, I'll go ahead and launch into the presentation. So basically what we've done so far is we've reserved an hour and a half. I can be very flexible about the time and we can free range a little bit on the topics. Obviously I have PowerPoints and prepared. Those will be provided to you after the presentation. I have a side job teaching at LCCC, and I've also learned that sometimes I don't like to provide the materials ahead of time because then people start reading ahead and looking at things that I'm not quite ready to discuss yet. So that's my standard practice. Mr. Chair.
Okay. If I can interrupt you, will you entertain questions during your presentation, or do you want us to wait until you conclude?
I'm happy to entertain questions.
Okay.
If there's a question that I plan on answering a little bit later in the presentation, I may defer that question. And if I don't answer anything at the end, this is your time, so you can keep me as long as you want.
Thank you.
The first part of my presentation I've designed as sort of a very compressed version of a board training that our office holds every spring to new Wyoming board members in state government. And that we will let you know when that training comes around again so that you have the opportunity to attend the full day training. Obviously, I'm going to give a fairly surface level version of the training. There's no real opportunity to get into the deep issues, but I'll do my best to touch on the important things that I think a new board and new board members need to know starting off. And I've also sort of focused that to be relevant to this board and specifically to charter schools. And then the second, or I suppose the third trimester, I suppose, of my presentation is specifically about this board, its enabling laws, and what its duties are.
I hate to interrupt you. Elaine, can I ask you a quick question? Is this meeting being recorded so that Professor Buss can view it later?
Mr. Chair, it is.
Okay,
yes.
great. Thank you. Sorry. Please go ahead.
Thank you. If I could just ask Elaine to quickly just click somewhere on the slide so that my little clicker works. There we go. All right. Okay, so I just want to run through some of the general concepts that I'm looking to talk about today so that you have a roadmap of where we're going here. I want to explain the legal support that our office offers so that you understand where we fit in the context. I want to talk a little bit about the general idea of what it means to be in state service. Some of you have been in state service before. Some of you not in the executive branch, but in the legislative branch. Things are a little bit different in the executive branch. So I'll run through some considerations there. We're going to talk a little bit about public records. With luck, this board and its members will not really have to deal with public records very often. And so that one I will endeavor to compress a fair bit. Open meetings, however, is another topic that this board will have to contend with. As a matter of fact, we've already had some intersection there as we've gone through this meeting. And then I'm going to talk a little bit about various ethics rules that govern executive branch employees, including the Ethics and Disclosure Act and executive orders. And then we're going to talk a little bit about the charter school statutes with an emphasis on board duties. And that one I expect to be maybe a little more free-ranging because I'm sure that will be the topic of the most concern to these board members. And so we will move from there. Okay, so let's talk a little bit about essentially what amounts to this board's legal department. The first one, the first part of your legal services that you need to be aware of is myself, your advising attorney. There are other attorneys in our office who will perhaps fill in or cover. We do have another education attorney in our office, Catherine Reeves, who is in the audience today. And so she is sort of number 2 to fill in, but I've taken on this board as my responsibility. And she has plenty of other projects to keep her busy. Don't worry about that. And my role is to provide general advice to this board, day-to-day advising. And the bulk of your legal questions are going to be directed toward me. We do, however, have other, and you can see my phone number is up there on the slide. We do, however, have other areas within our office that address very specific topics. So we have a contracts unit, and that unit is in a separate section. It's not actually a separate division. It's actually in the civil division within the Attorney General's office. And that unit, basically, their primary goal is to approve contracts. They're there to protect the state and to make sure that the contracts that we enter into adequately protect the state and its interests, particularly its treasury. We also have a personnel unit that deals with personnel issues within state agencies. Primarily, that unit advises the Department of Administration and Information, which has all of the HR functions of the executive branch consolidated within it. So they offer their advice in that sense. Every once in a while, I'll have some sort of HR or personnel type question, and that's who I direct the question to. Typically, their actual agency HR representative, which essentially you will share that function with the department's HR unit. We also assign conflict counsel as needed. You typically see this kind of a situation where we have contested cases and we need to have one part of our office essentially play the role as an advocate in a contested case process, and another part of our office be a neutral advisor to the decision maker. That's probably not likely to come up with this board as the law is currently written, but it's something that you might want to be aware of. And I want to talk a little bit about the role of our office, particularly your advising attorney, myself. Our role is really to provide advice, not directives. Now, I put usually in parentheses there because if a client agency is doing something that I think is really going to get them into trouble, I have certain ethical obligations to escalate those concerns. And there's no need to get into that. That's just something that to be aware of. I've never really had to do that. So it shouldn't be a major concern. The point that I'm really trying to make is that our role is to give you advice and to give you all the information, knowledge of consequences of actions, those sorts of things that you will need to make the best decisions. And that doesn't mean that you're going to make a decision that necessarily agrees with our advice, but it does mean that you should have the benefit of our advice when you are making those decisions. And it's absolutely fine for you to not follow our advice. We will tell you when we think that is a bad idea. But ultimately, it's the board's decision as the policymaker, as the agency, to make those decisions. We represent the agency as a whole, not any individuals as far as their individual capacity. So what does this mean exactly? Something that comes up commonly in a one-on-one type of setting is whether a board member thinks that they might have an ethical question that they want to work through, or they're not sure if they have a conflict of interest, those sorts of things. That's a situation where we would often have a one-on-one conversation with that board member to help work through, the ethical question that they might have. Now, we're not going to make the decision about whether it's, what course of action is the most ethical, but what we'll do is we'll try to, again, provide advice and try to help that board member work through those decisions. If you get a speeding ticket, I'm not your guy. So that's kind of the limit of our advice. But there is one thing to keep in mind. Generally speaking, attorneys owe a duty of loyalty to their client. And it's important to remember that our client is the agency. It's not any particular individual. And so, that governs all of our legal advice, and that shades kind of the way that we think about things. Most often, the contacts that we have with individual members, as opposed to a board as a whole, are typically with executive officers like the chair. But it's important to remember that even when we're talking to an individual officer as a representative kind of the board, we represent the board as a whole. So that's our interest, and that's where our advice comes from. And we do not provide legal advice to other entities. For example, in this context, charter schools. Charter schools would be seeking their own legal advice from their own attorneys. It's basically the same way that it works with school districts. School districts have their own attorneys that they hire in order to provide them legal advice. In representing the Community College Commission, I don't represent colleges. They get their own attorneys, and I represent the state agency. So just a few words about state service and what that means. It's important to remember that while you're focused on the individual work that this board will be doing, that you're part of what I would call an ecosystem of state government. That means that you are not an island unto yourself. You have a lot of services that are provided by other parts of the state government. So just a few examples of those. Administration and information, I mentioned them earlier, specifically in the context of essentially running the HR department for the executive branch. They do a lot more than that. They maintain the buildings in the executive branch. They're the ones that provide motor pool for state employees to travel to different places. They run the risk management program, which basically means that they're the ones who pay if somebody gets sued for some sort of tort claim while on state property or because of a state officer or constitutional violations. So there's a lot that they do. The budget department is another separate agency that basically hooks in with all of those other agencies. All of the budget requests for every agency need to go through the state budget department. And so they assist every executive branch agency with forming that budget request and help advise them on spending abilities when it comes to their appropriations. Enterprise Technology Services, that's another state agency that is essentially our IT unit. So all of you should have or will get your state-issued email account, and they're the ones who will provide support services for that. Those accounts go through them. If you lose your password and you need a password reset, that's who you're going to call to get that done. And they're the ones who are there to help. And of course, the Attorney General, that's what we do. We are another one of those support agencies. There are some functions that the Attorney General has that are independent of agencies. There are some things that we do that there either isn't a client for, or a client is the state as a whole. So for example, Cindy will be familiar with this, criminal appeals. That's something that we represent the state. We don't have a specific individual client. There are other circumstances, consumer protection type things. Contract litigation is another one of those where the Attorney General has exclusive authority over. But that's not true for most of our day-to-day work. And that's certainly not true as far as your interactions. And as far as you're concerned, we play a support role to your functions. One thing that I always try to hit on too is the fact that we may be the government, but we are not omnipotent. So executive branch agencies have limited government authority. Whenever contemplating any particular action, it's important to be able to identify what is the legislative authorization that we have to undertake any action. And most agency business is routine, and it's well established what their authority is. It's in their statute. It's not a big deal. And we also look for spending authority. If there's money to be spent, can you spend money for that purpose? It's important to know that as a matter of statutory construction, when we're looking at statutes and determining what an agency has the authority to do, the Supreme Court has told us many times that an agency authority should be narrowly construed. to what is explicitly set out in the statute or what is necessarily implied by what's in the statute. If we have a situation like that, we can get into the subject of what necessarily implied means. It's not black and white, I'm afraid, but depending on the circumstances, we can work through what that looks like. Turning now to the Public Records Act. By the way, I do have the statutory numbers. I have a slide later that's going to explain a little bit what I think is maybe the easiest way to access the statutes if you're not used to doing that, going through the legislature's website. So, and you will receive that as part of the presentation slides as well. So you'll have that for reference. The Public Records Act shouldn't ideally take very much time or effort, at least on the part of the individual board members, if the appropriate processes are followed. The general rule is that any records that are involved in the transaction of public business are open for inspection if they're in the custody and control of the agency. A couple of things to keep in mind is that under the law, it really doesn't matter how those records were obtained. It doesn't matter if they were generated within the agency. It doesn't matter if they were given to the agency by an outside party. The relevant question really is, does an agency have the records, and are they for the transaction of public business? So for example, if we received a public records request for an agency and we ran a search through ETS, that IT agency, and it turned up some, a pile of emails, and some of those emails were an employee making a doctor's appointment using their state email account. Number one, we would discourage that for this very reason. But more importantly, that email is not necessarily for the transaction of public business. So we would probably say that that's not subject to the Public Records Act and subject to disclosure. So that's just one distinguishing feature. There, of course, are going to be gray areas in all of these, but those are the types of things that we don't have a ton of case law on, and so we try to work through those issues if and when they arise. It also doesn't necessarily matter where they're stored or located, and this kind of gets me to the end of this particular slide, which is basically using your state account is the best way to avoid keeping public records separate from your personal records. There's nothing in the law that requires you to use your state account. However, not doing it, I think, is bad practice and lends to a circumstance where somebody might inadvertently run into problems with the Public Records Act. So we highly recommend that everybody use their state issued email account for that purpose. Just because the general rule is that records are open for inspection, that doesn't mean that every record is always open for inspection. The law provides essentially two categories of records that might not be disclosed if there's a public records request. The first group we sort of generally refer to as a may withhold category. And those are records that the agency has some discretion to either retain or withhold if certain conditions are met. There are, however, or there is a category of records that we would categorize as shall withhold, which means the agency does not have the option to disclose those records in response to a public records request. I have some examples here that are typical in the public records field. One is personnel files. And another issue that you all may have thought about or may be concerned with is FERPA records. And for those of you who are unfamiliar, FERPA is essentially the federal student privacy law. It does more than that. It actually, sort of the first job of FERPA is to make sure that parents and students have access to their educational records. But a second part of that is to keep them confidential and not subject to disclosure. That sometimes arises at the state level. More often it's a school district concern than at the state level, but to the extent that issue comes up, we're fully prepared to work through those issues with the board if necessary. And the best way to prevent those issues, again, is to use your state account. Which brings me to a point that I wanted to make. Obviously, you have only recently been issued your state email accounts, but there have been some records generated to, for example, set up this meeting, share the agenda, those documents. I would suggest that the board and the individual members find some way to get those into the custody of your department liaison so that they're properly preserved for the future in case there's ever a request. It'd be much easier to search for any public records in response to any request through the department rather than trying to have to contact each individual board member to try to retrieve any public records that you might have in your possession. So there are a number of ways to do that. You could gather them all and just give them to the department. Another way to do it, if all you have is emails, then simply forwarding them to your state email account would also accomplish the same thing. If you have records that are more than just communications, we can talk with the department about the easiest way to do that works for you. Once things are rolling and those are turned over, ideally, there shouldn't be any public records issues. If there's a request, then it should be simple enough to simply conduct a search using the state IT agency and provide the records as necessary without much board member involvement. So that's why I say I don't anticipate this board having to deal with public records all that often. Yes. Yes. Yes, text messages would also constitute records under the Public Records Act, and that is another form of record. Notice that I said, if all you have is emails, then you can just forward your emails. But if you also have text messages, then those should be preserved. It's probably beyond the scope of this presentation to walk through how to preserve those in the most efficient way. The department has the ability to basically plug a phone in and transfer text messages if you want to do it that way. Another way to do it would be to take screenshots and then send basically some record of that text conversation if there was one before today.
Mr. Chairman, Mackenzie, I just want to make sure I understand this. So our private emails and these text messages could be subject to scrutiny, but would that have to be done by subpoena?
Mr. Chair, no. And let me just slightly change your question. You say private emails and text messages. They're in your private accounts, but if they're in the course of conducting public business, so the business of this board, then they would be considered public records, even though they reside in your personal account. And there's no subpoena that's required for that, simply a request that those records be provided.
What about phone records of telephone calls?
Typically, a user does not have a record that would be generated through a telephone call. So it's only if there's a record that is produced. So for example, notes that you would take while you were doing your board work, or if there was a hearing and you were taking notes of the hearing. Now, those would be classified as public records. It's a different question as far as whether they should be disclosed. That's a separate analysis. But the first part of that is just determining whether or not they are public records.
Okay, thank you.
All right, we'll move on to open meetings.
Mackenzie, one, Mr. Chair. So would you recommend that we keep our business account separate, or even a business computer separate?
If you were using your state issued email address and Google account, then the device is actually irrelevant, because anything that is tied to that account will be accessible through our IT agency, so they'll be able to do it. Now, if you are doing something like saving Word documents on a personal device, then my suggestion would be to always put those instead on your Google Drive, which is cloud-based, and those then would be searchable by our IT department.
Thank you.
Let's talk a little bit about open meetings laws. The general rule, as I think all of you are probably aware from the title of the slide, is that meetings should be open, and the public has the right to observe meetings. There are some nuances to that. Obviously, not every government meeting is open. If I'm meeting with my client agency personnel, that's not open. It's just for the governing board of agencies. So it's only if we have a board or something like that. One-on-one meetings or committee meetings that don't reach the level of a board meeting, those aren't necessarily open to the public. You can always choose to make those open to the public if you wish, but you're not required to. An important point is there's nothing in the open meetings law that requires you to allow public participation or public comment. Most boards do to some degree. And so there's a spectrum. Some boards have as a routine matter parts where a section of the meeting where they want to receive public comment. Other boards have a process where somebody can request to address the board at a future meeting. It just really is at the discretion of the board. There are sometimes some specific questions about what constitutes a meeting, and our general advice, just for the purposes of safety, not that this is legally required. There are some other nuances to the law, but what we look for as a red flag is there going to be a quorum present? And that's what we look for in terms of, that's probably the number one determiner of what constitutes a meeting. Again, there are other characteristics of a meeting, so that's not the one and only question, but that's the first thing that we look for that raises a red flag. So the question might come up. I might be addressing this. Is it about lunch?
Exactly, thank you.
So the question comes up, what about sort of informal gatherings, meetings or departures? So it's not uncommon for boards to, have dinner after a meeting, or in this case, we're going to, retire to a separate room for lunch. My general advice is try to avoid talking about business, about the board's business. Failing that, it's not unusual to have side conversations or conversations with colleagues over breaks, those sorts of things. But certainly don't do it to evade the requirements of the open meetings laws.
Mr. Chairman, so Mr. McKinney, I have a question regarding replying all to emails.
Yes.
Because that was a big deal in most of the situations with charter school boards. I'm assuming that's probably a big deal here.
Don't do it.
Okay.
Yeah.
Yep.
Now there's, I say that a little tongue in cheek. There are, we don't necessarily look at purely administrative tasks like when can the board meet? What do your calendars look like as being something that's problematic? But my general advice for the sake of safety is that if there are emails or communications that go out to the general board members, the safest thing to do is blind carbon copy everybody on that. So it's a one-way communication and there's no ability for anybody to hit reply all and respond and start up a conversation. Understandably, you are generally going to be more concerned with the actual issue that's in the email, and you're going to have thoughts about that and you're going to want to share that. And so probably, open meetings is not going to be the first thing. I flatter myself in thinking that it might be the second or third thing that you're going to be concerned with. So in my experience, the best way to prevent accidental violations is to create a system or process that prevents accidental violations in that way. So I do recommend that blind carbon copy be the way that communications go out to the board as correspondence.
Thank you, Mr. Chair. Mackenzie, what does a quorum mean in this group? I've never sat on a board with an even number of board members.
Well, that is a good question. There's no particular guidance in the law that gives a general idea of what a quorum looks like. Some boards have it very specific what a quorum is in their enabling statutes. This board is not one of them. So I default to the general definition of a quorum, which is more than half. In this case, it means that you would need 5 or more board members to constitute a quorum.
Mackenzie, could we define a quorum as something less than a half, or could we expand it to more than a half, or is that?
I don't know the answer to that. As those of you who are attorneys know, I don't know an answer to a question unless I've had to actually find out the answer to that question. So that hasn't come up. Even if we think it might be allowed, I would want something that's either pretty clear in the law before I would recommend that. Otherwise, for the sake of safety, I would suggest avoiding doing that.
Mr. Chairman, do you think it might be just a good housekeeping measure to define a quorum as 5? Or did you have something else in mind?
Well, it looks to me like this might be something that we refer to a committee for discussion and then to have it presented to us at a meeting, maybe, if that's okay. Let's consider that.
Mr. Chairman, Mackenzie, what about committees? of, let's say that the chairman appoints a couple of committees, there be 3 people on a committee. Is that subject to the public meeting law?
So, Mr. Chair, not unless the committee is larger than a quorum. So typically, when establishing committees, we recommend that our boards establish committees of fewer than a quorum. So in your case, it would be using the standard rules, no more than 4 board members on a committee at a time. And it's not that anybody's trying to avoid the Open Meetings Act. It's just that committees are the places usually where the difficult, work is done. There's a back and forth, and there's logistical challenges to having, providing for public availability of meetings sometimes, and it's maybe a little more processed than committees necessarily want to go to. Now, I have seen some boards that do open up their committee meetings to the public, and that's always an option. But most boards stick to a practice of having fewer than a quorum in their committees.
Mackenzie, I think Colonel Roberts in his rules provides for a majority to be the quorum by default. I could be wrong on that. It's been a while since I've read those rules, but we did adopt Robert's rules subject to modification. So I think for purposes of today, and at least until we do something different, let's consider that 5 constitutes a quorum of this group. Is that acceptable to everybody?
Mr. Chairman, that was kind of my thought. As I said, just kind of a housekeeping clarity. That way we kind of know, and the public knows too, that you won't be seeing committees likely with more than 5 of the 8 members on them if we get to that point. So thank you for making that statement.
Yeah, I think that'll make it easier for all of us, at least at the outset. And we can change that if we choose later, but for now, let's consider 5 as a quorum. Thank you.
There are notice requirements in the open meetings law. A public meeting doesn't do any good if nobody knows that they should be there, including board members. So there are some notice requirements, but the notice requirements depend on what type of meeting the entity is having. And there are 3 types of meetings that are set out in the statute, and this is where we intersect with what I interjected with earlier. I don't have them on here, but I can briefly cover them. There's an emergency meeting, and that requires no minimum amount of notice, just as much as the entity or the board can provide. Those are typically reserved for some situation where there's going to have to be some danger to the public that requires immediate action on the part of the board. So we see this, well, I personally see this the most often in something like a licensing board hearing where there's a healthcare practitioner, let's say, who, it's considered very important to, suspend their license because they might be a danger to the public. There's a whole process provided for that in statute. I don't anticipate that this board will have much of a call for emergency meetings. If you do have to have one, then it needs to be followed up with a special meeting within a certain time frame to ratify any actions that were taken at the emergency meeting. So most of the time, it actually makes more sense to schedule a special meeting, which is the second category of open meetings that we have, and that's a special meeting. That requires 8 hours notice, according to the statute. We typically recommend at least 24-hour clock hours of notice. The distinguishing features there are that notice has to be provided to the board members and to any members of the press or media that have, and I think maybe anybody else, it's been a while since I've looked at that exact provision, who've requested notice of any meetings. So it's a fairly short notice period. It's only, our best practice 24 hours. So there's a lot of flexibility there. Though the one thing about a special meeting that is important, as I mentioned earlier, is that the board cannot go outside of what was noticed in the meeting. And so the board is essentially limited by the scope of its public notice. And usually that means the agenda that was provided as part of the public notice.
Does creation of a notice on a website constitute adequate public notice?
I don't think I'm going to answer that question exactly. I will say that it's common practice in terms of public notice to provide those notices to the public on a public website. Some agencies do choose to issue press releases when it comes to their meetings. Certainly not all agencies, but some of them do. I don't often see those press releases get taken up by the press. And so, but nevertheless, the press release is there.
So as I understand it, if an individual of the public requests notices be provided, that is mandatory in addition to whatever other public notices. Am I right on that?
I would have to look at the exact wording of the statute. It may be any member of the public, or it may be just members of the press or something along those lines.
Okay.
But I would say that certainly best practice would be if anybody, regardless of what the law says, if anybody requests notice of upcoming meetings, that there be a list, that is kept by the agency to make sure that those notices goes out to those individuals who requested that notice.
Thank you.
Mr. Chairman McKenzie, are executive sessions authorized under the Open Meeting Act? And if so, when?
They are authorized under the open meetings laws, and thank you for transitioning right into my next topic. So they are allowed for a very limited set of purposes. One of the areas that I advise the most frequently during board meetings, as a side to before or after, is whether or not an executive session is allowed. Specifically, the open meeting procedurally requires that there be a motion and that the motion state the reason for the executive session. There's a few ways to do this. Probably the easiest way is to specifically refer to the statutory justification. So it would say something like, if it is to consider, let's say it's an agency that has an executive director and they're doing a personnel evaluation. So it would be something like, I move to enter executive session for the purposes of conducting a personnel evaluation under Wyoming Statute 16.405A2. That would be an example of what I would consider to be an adequate motion. And that helps keep the board grounded and tied to those statutory reasons. So I think that's part of the justification for requiring that. And there must be a second, and there must be a majority vote as part of that process. The most common reason that I see for executive session is probably executive director evaluations. That's not an issue with this board at this time. The next most common, which is something that I would expect from this board, would be to receive legal advice. So legal advice is privileged and confidential, and generally speaking, our office would prefer to give you that advice in a closed session so that we can be frank with you about what we think of proposed actions or our interpretations of the law, and then you're able to take that information, deliberate what you're going to do in open session, and then go ahead and make your eventual decision. Importantly, when in executive session, the board must adhere to the reason for the executive session. So, for example, if you go into executive session in order to receive legal advice, then you wouldn't be able to then switch subjects while in the executive session and talk about something else, even if that something else would otherwise be allowed under an executive session. In that case, you would need to go out, take another action to go into executive session for the new reason, and then go into executive session to discuss it. And that is all to give the public notice about what the general topic is that you are going into executive session to discuss, and to make sure that there's enough information to evaluate whether or not the executive session was proper.
McKenzie,
Yes.
if we were to go into executive session, who would we ask to leave, or would we ourselves leave? And who would stay? I mean, for example, would Elaine stay? She's the liaison from the department.
That is a good question. It has come up in our office before. So in terms of who leaves, it really depends. That's more of a logistical question than anything else. In terms of, as far as mechanically, do you leave and go into a separate room, or does the public leave the room that you're in? In a case like this, where we have a hybrid meeting and the technology is set up to have a board member, remoting in, I might suggest that it might be easier to ask the observers to leave. In terms of who has the ability to go into the executive session, that's at the sole discretion of the board or entity that's holding the executive session. So, for example, in boards that have executive directors, it's often a routine practice for them to have a member of their board staff there to take minutes, for example, during the executive session. And it is required to take minutes during executive session. And so there will be a member of staff there to perform that function. But obviously, if you have an executive director evaluation, then you can't really have a member of staff there. So they'll go ahead and exclude any of the agency sort of lower level personnel while they conduct the personnel evaluation. So really, it just depends. Whoever is in the executive session is going to be held to the same confidentiality law as anybody else. So board members, anybody that the board members allow into the executive session, it's required that the executive session be kept confidential.
So that's my next question, which is the legal concept, we look at employees of the attorney as being covered with the privilege. But these are not employees of the board necessarily.
Yes.
So how do we draw the line, and where do we draw the line?
In terms
If we're getting legal advice.
Sure. In terms of, so are you asking if you have a legal question, or if I've said I have some legal advice to offer, who could potentially be in there?
Yeah, if we're receiving legal advice, I don't want to inadvertently waive the privilege.
Sure. Yeah, and that's kind of an intersection of two issues, which is there's a confidentiality that's provided under the open meetings laws for what happens in executive session. But then there's separately a privilege that attaches to the attorney-client communications between, let's say, myself and you as the board members. I don't know that we've ever really hashed that out. What I would say is, for the most part, when we have that kind of a situation, the boards usually include in the executive session only those people who are, from my office giving the legal advice, or those who are acting as agents of the board in some way. And so they don't necessarily break the privilege. So along the lines of, having several members of a corporation, in a meeting with the attorney, to the extent that is, to the extent there is somebody who is, let's say, a third party, that's not something that I'm really prepared to advise on. That's something that we should probably discuss in executive session. Another question.
Thank you, Mr. Chair. Mackenzie, a few months ago, there's the reality of what the statute says and what law says. There's also then the perception, right? Which is in part why you discuss why you're adjourning into executive session. I was watching a meeting, and I found this fascinating, where the public was asked to leave the room and the entire agency staff stayed. And I will say the perception of that meeting was quite poor. What are they doing that the whole staff has to be in there on executive session with the board?
Public perception is certainly a factor that this board will have to consider in making those decisions.
Well, you can look at the law, but I think you'll find that unnecessary people tend to waive any confidentiality or privilege that associates. So we'll wait for your discussion on that when the time arises.
Right. So one other item that I did want to add in there is that your advising attorney should always be in the executive session. I've been on numerous, individual performance evaluations, even though I'm not the HR attorney. Primarily in those kinds of circumstances, my goal is to try to make sure that the board doesn't stray from the reason that it entered executive session. So it is not uncommon for me to have to observe the conversation wandering into a related area. Maybe the executive session was to address a specific question, and now the conversation starts moving into a broader policy consideration. Well, what should we do in cases like this? Well, that's more of a question that needs to be debated and discussed in open session.
Mr. Chairman, there is some parliamentary law that allows for the decision to be made in executive session Does the law prevent that?
It does. The board can take no action in executive session. There is no exception to that requirement. Typically, when I have a board who is in executive session and I hear someone say, is there a motion to leave executive session? My response is, you can't take any action. So I think there's no motions that are permitted. No decisions can be made. That's not to say that the discussion might not allow the decision-making body to perhaps arrive at a consensus, or it's seeming that way, but the actual action must take place in open session. At this time, I want to check in a little bit with the department. I know that lunch was on a clock of some kind, and I want to see kind of where we are.
We're all interested in this.
Mr. Chair, they will be ready for us at 1, but I think they'll be here a little bit early, so we're kind of keeping an eye on that.
Okay, thank you. I want to briefly talk about rulemaking. The reason that this is going to be brief is because this board doesn't have any explicit rulemaking authority in its enabling statutes. So I want to talk a little bit about rules so that you have some familiarity. The charter school rules that currently exist and are authorized are only for the application process and the application form, and those are under the purview of the department. But I do think it's worth at least touching on this subject for everybody to have a passing familiarity if you don't already. I know some of you have great familiarity, but just trying to cover all the bases here. It's important to remember that when there's a properly promulgated rule, it has the force and effect of law, just the same as any statute. It might be arguably more vulnerable to attack because instead of the Constitution being the floor, you have statutory authority being the floor. But generally, it's pretty accepted principle that agency rules, when properly promulgated, have the force and effect of law. The agency is limited in what it can do by rule, by what authority is given to it. I touched on this a little bit earlier. The agency authority is delineated by its enabling statute. So, if a statute says, for example, that a board can, pass rules having to do with application for a license, but it doesn't say anything about passing rules for, disciplining somebody in connection with that license, then they don't have the ability to pass rules on that subject. So this board does not have any rulemaking authority located in your enabling act, which I've already mentioned. The only charter school rulemaking authority that we find is the department's, and that is to prescribe the application forms, including the renewal forms, establish application review procedures, which does include the timeline, and they can, but they don't have to, provide a process for mediating disputes, specifically about whether an application is complete.
Mr. Chair McKenzie, I'm confused. So we have responsibilities to adhere to the rules that the Department of Ed establishes, is that correct?
Yes, to the extent that they impact your purview, but I don't know that they do all that much. When we get into this board's responsibilities, that can be something to keep an eye out for, as to what extent that the application rules set by the department impact what you're doing. When I say that there's these statutory lines and the board doesn't have rulemaking authority, the department does, I in no way mean to suggest that there shouldn't be a dialogue between the two agencies in making sure that everything works synergistically with each other. That is a critical part of most areas of state government, is making sure that agencies that intersect in some way are communicating with each other and avoiding any possible conflict. Sometimes it does happen, but for the most part, agencies are pretty good about ensuring that it doesn't. So I think when we start talking, maybe keep this in mind when we start talking about the board's responsibilities. It can set policies for various things, and related to its duties, and we're going to talk a little bit about that later. To the extent, let me put it this way, I haven't seen an obvious way that the department's rulemaking authority when it comes to the application comes into conflict with this board's responsibilities as set out in the statute. That's not to say that it couldn't come up, but I haven't thought of one yet. You all may be more creative than me. In fact, I guarantee it. And so maybe you can come up with one. But generally speaking, the solution when that happens is to make sure that the two entities are communicating to avoid. Yes.
Mr. Chairman, could I follow up on that, please? So am I correct in understanding that what you're saying is that any policies, procedures, or anything that we do as this board is subject to the review and approval of the WDE?
That is incorrect. No, I'm not saying that at all. The department has rulemaking authority over specifically the items that are listed in the statute, which I've reproduced on the slide. So the application forms, which include the renewal forms. So the physical, put this information in this box kind of thing. So that form. The application review procedures, just the procedures, including timelines for application components. There's another place in the statute, and this is getting a little bit in the weeds, where it talks about a phased application process. And so I think that's a little bit of what this is designed to address, is what does that sort of phased application process look like? That's what the timelines for application components would be. And it also means, right now in the charter school rules, there is essentially a window for applications to be received. And that's what the department has set in a way to most effectively, I guess they can speak to this, but my recollection is that it's to essentially enable a window to create a defined application period, so you don't have applications coming in all the time. I don't expect that to be an issue for some time, given the current cap on charter schools. But
Well, if I could, Mr. Chairman, follow up with another question. What about our decisions as far as authorizations? Are those subject to review or being overturned by WDE?
no, they're not.
Okay, thank you.
Mackenzie, oh, I'm sorry, go ahead, Janine.
So Mackenzie, when we get there, maybe you can help me. I'm quite familiar with policy setting, after being on the school board for 20 years, but perhaps when we get there, you could explain to me from the public review process, the difference between policy and the rulemaking processes.
Absolutely. Those are defined in the Administrative Procedure Act. So we do have statutory definitions that address those.
And kind of as a follow-up, if we have competing applications for a limited number of charter school authorizations, it looks to me like the statute does not provide much guidance in how we make a decision among competing applications. It also looks to me like that would be an area where applicants would like to have some guidance and like to hear from us in advance. Is this something that you can help us with, or should we go back to the legislature and seek some further clarification?
Well, the latter is always an option. So let me just say that, asking the legislature for more detailed direction is always an option that any agency has. So, but in terms of what you are able to do, that is probably best addressed in the context of a specific proposal about how to resolve these. So the statute does provide some criteria to evaluate new applications, but as you say, it doesn't really say like what is better. It doesn't give like priorities, and so it's not as helpful in that way. As things stand, I think that amounts to a discretionary decision on the part of the authorizing board. If that situation were to arise, what I would be looking for if the board was distinguishing those two things, number one, you could perhaps set some policies as far as how the board is going to evaluate these things. It gets a little bit tricky when we start talking about the difference between policies and rules, regardless of whether they're promulgated as rules or not. That's a whole separate conversation. But the important thing that I would be looking for in a situation like that is whether or not the exercise of the board's discretion is justifiable. If let's say the applicant who didn't receive the charter award then goes to court and says that this board acted arbitrarily in a, or, without foundation, what I would be looking for is to find the board's reasons and to be able to accurately and completely state, here's why the board decided the way that it did in order to defend against any accusation that the board acted arbitrary. In other words, it wasn't arbitrary. The board had reasons. These were the reasons that the board decided X charter school over Y charter school.
Do we need to issue some sort of written, I come from the legal world where there would be an opinion by a court. But this might just involve a discussion among the board members. Does that need to be preserved in some written fashion as the justification for a decision by this board?
That would perhaps be useful. I don't think that there's a legal requirement that happen. There would be a record of the discussion. The trouble with the discussion, however, is that most often reflects individual board members' opinions and their own reasons. It doesn't, one individual board member's reasons for taking action do not necessarily reflect the entire body. And so typically, I think it would be as a safe bet you might think about when we get to that point, issuing what amounts to a board order that explains the justification for why the board chose as it did. That I kind of put into the category of it's one of a long list of possible options the board has and things that it will have to consider moving forward as far as its standard practices.
Thank you.
Mr. Chairman, is it possible to go back now and ask questions earlier? Are you finished? I noticed that you mentioned the AG's office has a contracts unit. And behind that, it says that approves contracts.
That's correct.
Do they review our work as a board as far as applications and the agreements we enter into with charter schools?
So they historically have reviewed the charter contracts, but not for the substance that you would be reviewing them for. In other words, all of our standard state contracts have certain provisions that we as a state insist must be in all of our contracts. So for example, they include provisions preserving our sovereign immunity to make sure that we can't be made to pay money damages for certain things, certain indemnification. That's what our contracts unit primarily is looking at in terms of protecting the state. They don't take a position on these policy issues. So for example, they wouldn't be looking to make sure that a particular, let's say closure requirements of a charter school that are put in that agreement, they wouldn't look to make sure that those are sufficient. That would be outside of their review. So they do review our contracts, but it's for things that are standardized around the state and sometimes particular in exceptional circumstances, but nothing that I would anticipate would intersect with this board.
Would the applicants or us have any recourse if the AG interfered with one of those?
I mean, not really, no. Our office, looks at those contracts. All I can really say is that the things that they're looking for aren't the types of things that you would be deciding. You would be deciding stuff that's specific to the charter school. What are the, what are they obligated to provide as far as educational services? What are the measures that they're going to be assessed on? Those kinds of things. That's outside of the scope of our review. The issue that comes up most often in contract negotiations when I'm representing agencies, because I do negotiate contracts, I'm just not the final authorizer in our office for the form of the contracts, is, some vendors, for example, they don't particularly like our sovereign immunity language, but we insist on that as part of our standard state policies, those sorts of things. But so far, we haven't had any pushback on those provisions.
But your answer is there's no judicial remedy available to us
I don't believe
if we
there is.
disagree. Okay. Is there any statutory language that designates the chairperson of a board like this as being the official spokesman for the board?
There is not.
Is that something we need to agree to as a board then?
For the, well, I can tell you what I've observed across boards in Wyoming. Generally speaking, I've seen only a few boards have any kind of defined policy on this topic. The one that comes to mind is the State Board of Education. Had some need for some policies a few years ago. My memory is not very solid on exactly what the circumstances were and what the policy actually says, but they did address that in a policy. Most of the other boards that I work with, they don't have anything that's specific written policy. It's improvisational. And so that's kind of how they proceed. So there's no legal requirement that you do something like that. Some boards have done it as a matter of judgment. And so if the board wanted to do that, that's certainly something that it could do.
So is there any statutory language that prevents individual members from being able to have their own, speak publicly about their opinions as long as they are clear that they're not speaking for the board?
No, I think I think you've hit on exactly what needs to happen there, which is that the roles need to be clarified, that somebody is speaking as an individual. Now, we do consider there to be a fiduciary obligation as a board member to further the objectives that the board is deciding. And this is something that I cover a little bit in the ethics portion of this, but essentially the short version is there can and should be robust debate and discussion amongst the board members when deciding on a course of action. But once a decision is made by the board as a body, each member has an obligation to further that decision, regardless of whether you agreed with it at the time. So that's one of those duties there. Now, that's not to say that you don't have the ability to express your opinion as an individual person. You do. But there is kind of, as a board member, you have sort of a higher additional duty to further the objectives of the board as the board decides it. I would add one other cautionary note when we talk about making public statements. This is a body, and so this body only makes decisions collectively. And so one board member can't necessarily represent the views of the board unless the board as an organization, as an entity, has actually decided that that's what its position is. So for example, if it's a legislative session and somebody has a question about a draft piece of legislation that the board just hasn't discussed, then none of you would be able to offer a board's position on what that legislation does or an opinion about what that does. You might be able to offer your own individual opinion about that. But since the board hasn't taken a position, then there is no board position to offer in that circumstance.
Well, as an example, if we as a board denied the authorization of a charter, and the chairman of the board disclosed that as a public decision, and someone on the board disagreed with that, would they can they legally talk to in the general public, I mean, obviously to the applicant or whoever about the issue?
Certainly.
Okay, the last thing I have, sir, is the funds that we have available to us. I'm not sure, I know what the statute kind of says, but I'm not sure how that becomes available to us. And what is the budget process for us as a board?
That's a big question. I understand that the department actually has somebody who works in their finance department who will be addressing that in a bit more detail. As far as what the legislature has set out for funding, there's a couple of pieces to it. There is in the statute itself, which is what we call codified. So it appears in the statute books and it has a number. And that is, there's a provision that says that any authorizer, it's not specific to districts or this authorizer, can essentially assess an administrative fee of up to 3% of the amount that each charter school receives through the normal state funding. And that's really all it says. Separately, in the supplemental budget, or what I would call the Supplemental Appropriations Act that just came out of this last session, there was appropriated $280,000 to the Department of Education to support the department and this board in accomplishing the charter school duties and administering the charter school system, essentially. That provision, I don't have it right in front of me, but it authorizes an additional position and specifically says that the funding can be used for one position in the department. Also, perhaps salary increases or increased compensation, I think it says, for other individuals, and also sort of support items like technology and those sorts of things. So that's the only funding and that's the only appropriation that is relevant or that goes to state level charter activities in the state.
Mackenzie, I don't want to interrupt, but
Okay,
let's
thank
take a brief recess to let people regather their senses. Okay, maybe 10 minutes, is that adequate for everybody? This is not lunch necessarily, but unless lunch is available.
I'm not sure, Mr. Chair, they're checking right now, so.
Okay, well, let's take 10 minutes, and if it is available, we'll extend it to be the lunch
Okay,
break, if
perfect.
that's okay. Thanks. Mackenzie, are you ready to move forward?
Mr. Chair, yes, I've been told that I have to re-share my screen, so I'm going to do that
Okay.
now.
We're ready to resume. And would you prefer I called you Mr. Williams, or is Mackenzie okay? I mean, we've been pretty informal, but we could be more formal if you'd like.
You can call me anything except late for lunch.
Okay. Okay.
All right, well, that was a sort of a natural break there, talking about government ethics. So let's get into this a little bit. Now, I'll start this off by saying this is obviously a vast and broad area. So my goal here is to have a discussion about some of the features, some of the things to look for. I'm going to be referencing statutes and executive orders. Those are or have been provided to you in terms of the executive orders. The statutes, obviously, I'll kind of show you in a little bit how to get to those statutes. There's no way that we can cover everything in this session or even probably multiple sessions. So you are going to have to be responsible for going out and reading those yourself. And I'm happy to answer any questions once you do, but I just want to be clear that these are things that you're gonna have to read. Similar to me when I first started at the AG's office, Executive Order 1997-4 was given to me and I was expected to read it. So it's not that dissimilar from a government employee. So
So the governor's office provided me with a copy of that. I don't know about everyone else. Did everyone else get a copy of that 1997 executive order? And
I put a copy in a shared drive that Elaine and I had, but she might not be aware of it.
okay.
So one way or the other, it will be sent to the
Okay.
board members.
All right. Let's make sure that happens.
So
Excuse me, Mr. Chairman, are you talking about the document that Geringer administration put out? Is that what you're
Correct.
talking about?
that's correct.
Yeah, that is certainly something everybody ought to look over.
So we're going to cover some features. So that we're going to start with the Ethics and Disclosure Act. That provides general responsibilities for those individuals who are employees as the statute defines it. Now that does include board members, but it's not as broad as you might think for our common understanding of employees. But it doesn't necessarily matter for your purposes. I think you just need to know it does apply to you. That's the important part. Some prominent features of that, I'll go over some of the main sticking points here. You may not accept gifts in connection with public service. That's one of the prohibitions on there. One of the things to keep in mind, however, is that the definition of gifts has a lot of little twists and turns and exceptions and those sorts of things. Generally speaking, a gift is defined as anything that has a value of over $250. Somebody might ask, but I don't know, because I've never had the need to research this. I don't know the last time that this dollar amount was changed. So I don't know that it started out at 250. I don't know if it's changed over the years, but at least right now, 250 is where we're at. There are a lot of exceptions to what constitutes a gift. So for example, travel and accommodations to a conference might not classify as a gift. Obviously, gifts from family members for your birthday don't count as gifts under the Act. Purely memorial, so, a little plaque that you get at the end of your board service, that doesn't constitute a gift. So there's a lot of different exceptions. The list is long and exhaustive. So I would suggest that you take a look at that list specifically. Another feature of the Ethics and Disclosure Act is what I would call the anti-nepotism provisions. And generally speaking, I think we're all pretty familiar with that. The Ethics and Disclosure Act doesn't necessarily say that you can't hire or supervise any family member. It lists out the family members that are prohibited in that respect. So I don't remember the exact delineations and I don't have it right in front of me, but certainly spouses, children. I think it goes so far as to say nieces and nephews, but probably not grandnieces or, nieces or nephews once removed. That's always confused me a little bit, the removal process. I learned it once, but it slips my mind sometimes. So there's a point in your family relationships where the anti-nepotism provision of the Ethics and Disclosure Act does not apply. It doesn't mean that there couldn't be some other ethical obstacles, and that's one point that I want to make. We're talking about several different sources of your ethical responsibilities. There is some overlap between those things, but there's also some things that the Ethics and Disclosures Act might cover that Executive Order 1997-4 does not, and vice versa. So, generally speaking, the Ethics and Disclosure Act prohibits using public office for private gain, either for your own as a public officer, either for your gain or for anybody else's. So, remember, that's private gain. You are expected to use your office for public gain, and that's exactly what you're appointed to do. And that's what the charter school system is supposed to do, is to advance the legislature's public policy in terms of having a robust and charter system. And so those types of decisions, even though they might incidentally benefit an individual, that's incidental. Your duties are oriented toward providing that public benefit.
Real quick. One of the, I think, fairly new requirements is that the charters be managed by independent board members. Are we talking now what constitutes an independent board member?
To a degree. By way of background, I think for that question, the charter school law does explicitly say that the individual charter school board members are subject to the Ethics and Disclosure Act. And then there are some additional provisions that govern it restricts a little bit who can be a board member in these organizations. So for example, a board member cannot be an employee of an educational service agency that the charter school is using unless the authorizer gives permission. There's an out there if it's necessary. I probably don't have the answer to your question. I would have to probably hear it again and look at the statute, and that would be more of a thought process. I don't have an answer on the tip of my tongue.
My concern is, what is independent? And this to me starts to sound like how we could think about whether a person is independent. And maybe I'm reaching for something that's not there, but thanks.
No, that makes a certain amount of sense. And to the extent that there are questions where the board needs to think about a framework for deciding certain things, the Ethics and Disclosure Act may present maybe a model or inform that decision. And so that might be worth thinking about. We will move on to Executive Order 1997-4. The short version of what this executive order does, and you're correct, that was Governor Geringer who issued that executive order, and it has never been rescinded by any following governor, so it is still in effect. Generally speaking, the way that I explain this to lay board members often is that it essentially took the Ethics and Disclosure Act and it applies it to all executive branch employees and officials, and then adds a few additional obligations. And so Generally speaking, the things that are violations of the Ethics and Disclosure Act, if a person subject to that act did them, would also be a violation of 1997-4. The most notable obligation that is added in that executive order is the command to avoid the appearance of impropriety. That is a fuzzy concept for a lot of folks, and that can be difficult to apply in some circumstances. That is a frequent call that I get in my office from individual board members who say, here's this circumstance, do we think there's an appearance of impropriety, or do I have a conflict of interest? Those kinds of things. And so I will work with that person on kind of going through what that looks like. A few things to keep in mind when it comes to conflicts of interest. Number one, we're looking for real conflicts of interest, not just something that is speculative. As a matter of fact, something that is an appearance of impropriety is not just anything that looks a little bit hinky to anybody, right? It's something that specifically, if a reasonable person knowing all of the relevant circumstances would be satisfied that no impropriety exists. So it's not just if it looks bad to the random stranger off the street. That's not necessarily the measure. Now, I will say that there is a tension. There's a tension here between your obligations as public officials and the need to perhaps recuse yourself in some circumstances. And that tension arises in edge cases. Obviously, you have an obligation to recuse yourself if it would be a violation of the Ethics and Disclosure Act or would be a clear conflict of interest. And you also, as a board member, you have an obligation to participate and to express your opinion and to vote on measures that come before the board. What happens is there's a bit of a gray area there where something might be a conflict of interest, and it's easy to say, well, I'm just going to recuse myself because I'm not sure if it's a conflict. That's okay to a degree, but it's also important to remember that your purpose for being on the board is to be a board member. And so you do have an obligation to vote on things unless you have a conflict of interest. So it's not an easy thing to resolve, and that's something that I can talk about or talk through with individual board members to the extent that it ever comes up. But it's important to remember that your public service includes voting. It's really important for you to express your opinion and to make decisions in the public interest, and the board is less well equipped to do that the fewer board members that are actively participating. So that's an important thing to keep in mind. I do want to touch a little bit on Executive Order 1981-12. This is one that I don't think will come up very often, but it could. Primarily, it governs two types of processes. It governs rulemaking, which again, you don't have rulemaking authority, but you may in the future, if at the legislature's discretion. And it also includes communications in contested case proceedings. This board also doesn't have contested case processes, but again, that could be something that arises in the future. Essentially, what it does is it governs ex parte or one-sided communications in those types of proceedings. The idea being that the board work is public and all board members need to have the benefit of all of the input that it receives. Without going into a whole lot of detail, because the executive order is pretty explicit about the process to be used when a board member receives an ex parte communication. It recognizes that you don't always have control over those things, and so it lays out some processes. But generally speaking, the executive order basically tells everybody to avoid receiving comments outside of your actual public comment process when we're talking about rules, and then for contested cases outside of the contested case process. Not something that you need to worry about too much. We provide it for your information. And in the event that the laws ever change to provide rulemaking authority or contested case processes by this board, then that's something that will become more prominent. A few other sort of broad general points about government ethics. I think it's important to remember, and I've already covered this in some detail, your obligation is to express your opinion and to vote according to what you think is the best policy within your statutory powers. your obligation is to serve the best interests of the state and not the people of Wyoming, particularly constituent groups. This happens sometimes where membership on a board, your eligibility for membership depends on your membership in a particular group. So for example, somebody selected from the business community, or in licensing boards, sometimes we have sort of a, people who, the Board of Nursing has people who have different types of nursing licenses, for example, compose that board. And sometimes there's an assumption that because you are selected from a certain group, that it's your job to represent the interests of that group. And that is not true. You might be selected from that group because that group provides a unique perspective, and it provides background information that the board might otherwise lack in making some of these decisions. But your ultimate responsibility is to the state of Wyoming and to make the best decision for the people of the state of Wyoming. Sometimes that means that board members have to make decisions that they think are in the best interests of the state, but might go against the group from which they were selected. And that's a difficult thing to be confronted with. I don't think that we'll have that issue, particularly with this board, because while there are qualifications that are set forth in the statute, none of them necessarily have a particular defined group that you were selected from. So I've already touched on this as well. Just because the situation is difficult doesn't mean that you can recuse yourself. You are here and you're appointed to make the difficult choices. And some of those choices could be unpleasant. If you have 2 charter schools in front of you, each of them is excellent, but you only have 1 slot, you're going to have to make some hard choices. And simply recusing yourself is not a really viable option. And I've already touched on this earlier in my presentation. Disagreement amongst board members is absolutely allowed, healthy, necessary for a robust decision-making process. But undermining the commission's final decision is outside of your ethical boundaries. And as always, just a little plug, you are encouraged to consult with me. In case you're wondering, I don't make any extra money. I don't charge by the question. So as a matter of fact, I am free to you. So feel free to use me and to use our office. How are we at?
Chairman and Mr. Williams, if I may. So for instance, if I was presented with a difficult decision, or possibly had to decide between 2 charter schools, and I went out to look for more information. So in other words, consulted with, I have quite a few colleagues in the educational field, and asked for their opinion and so forth. Can you give me some guidelines along that? Or is it something that, I'm not allowed, or what's the guidelines? That's my question. To get more information for myself, or maybe other educational experts or other experts in a particular field.
That is an excellent question. And I don't know that I have a definitive answer. What I can try to do is to provide a little bit of a framework and some considerations to use in those circumstances. Definitely, that's the kind of thing that I would want to have a conversation with you as a board member, before undertaking any of those activities. So generally speaking, and this is a little bit of a lawyer characteristic, we're very wary of going outside of what was presented to the body. So the body is going to, for example, a charter application, you're going to receive an application. The application is required to receive certain things. And they will include, basically everybody on the board is going to be presented with the same charter application, the same packet, the same information. The charter application process also provides for a public hearing. And so at the public hearing, anybody, including the experts that you're referring to, can come up and speak to the charter board about the merits of the particular applications. And that's an opportunity for the body as a whole, as opposed to individual members, to receive those opinions. I don't know that there's any squarely, there's any square law that explicitly says you shouldn't go outside of that. But I will tell you, in the context of something like a court case, that's absolutely prohibited for somebody who, like a juror, to do, for example. This is not that situation. I don't want to analogize too much to an actual court case. It's not a good fit. But that's the reason why it makes attorneys uncomfortable to hear about going outside of that. In that kind of a situation, I might try to come up with a creative way for you to still get that information, but to enable the entire board to have that. So for example, to make sure that notice of the hearing goes out to the individuals that you're thinking about who might be able to offer their opinion. That way they can do it to the entire board as opposed to just one board member. So there are ways to still accomplish, I think, what it is that you're looking to accomplish. There's always an alternative way to do those sorts of things. So I'm not offering any particular guidance or advice until the situation comes up, but those are just some thoughts about that. That's an excellent question, and it's a complicated answer.
Kind of along those lines, Mr. Chairman, I have a little bit of a question regarding, some of the schools that have already, been approved by SLIB, and then as we are moving forward, I have a desire, I'd love to go visit those schools, tour those schools, and get a good understanding of the schools that we're governing or authorizing. And I think, and so I'm just curious, in that realm, what's the impact there? Or do you have a negative feeling about us engaged in that practice of actually going and seeing how they operate? And I feel like for me, it would help me better understand, how to be more suited for this seat, if that makes sense.
Absolutely. Let me say something general, and then I'll also suggest that probably that needs some more study and some actual legal advice before undertaking those sorts of things. But in general, I feel a lot more comfortable with something like that because there isn't a decision currently pending in front of the board. There isn't an application. Now, there's an ongoing monitoring process. But I am likely to suggest maybe that there be sort of an established, maybe the board wants to hold a meeting at one of the charter schools, and as part of that meeting, could take a tour of the charter school, those sorts of things. That would be permissive. My main concern is making sure that we don't have one board member getting information from which to base a decision on that the other board members don't have access to. That's my main concern.
So let me expand on that a little bit. Seems to me that we all come with a history.
Mr. Chair,
It's all different.
can you put on your microphone so the people on Zoom can hear
It
you?
is on.
Oh, it is? I'm sorry, I couldn't hear you.
I'm soft-spoken. Sorry, Elaine. We all have a history. We all have experience. And this is a way of expanding that experience. If it's not information from a party, that seems to be okay, to me at least. I have a family full of educators, and we might discuss educational things at any moment, certainly over family gatherings. But none of them are going to be here with a charter application. And yet it's going to become part of my history, if you will. So I guess, to me, that seems the dividing line. Is it a party you're getting information ex parte, or is it just general information you're seeking out about something? And maybe the question that Joseph raised, which is, what do you think about this particular charter, is the wrong question, but rather, what do you think about this educational philosophy would be an okay question. So when you're thinking about that, I wish you would think about it in those terms, maybe.
Yeah, before I get to this question, that is a useful framework, and that's why why I think having a pending issue before the board is certainly a hugely relevant factor between the difference between the two scenarios. And I would agree with that. All of you as board members were selected because of your current life experience. And I think that you would, maybe you don't have an ethical obligation per se, but hopefully everybody continues to learn about the subjects that the board is generally dealing with as you move forward in your service with the state. Nobody should, this should be an ongoing educational opportunity for everybody. In order to make the best decisions possible, you need to expand your knowledge. And some of that will come formally through learning, from an application that, proposes some things that you're not familiar with and you have to learn about them. And some of it will be through continuing your life experiences that made you suited for the board in the eyes of your appointing person or entity.
So, Mr. Chair,
Go ahead.
On our school board, we brought in a trainer. And one of the exercises that she did was she divided us into teams. And she gave us all information, trying to get to a decision. 3 of the teams had the same information. The 4th team had more information. And at the end of the day, as you go through the exercise, the 3 teams that didn't have what the 4th team had all said, well, if I'd had more information, if I'd had that information, I would have made a different decision. So to me, that's just sort of a word of advice in terms of boardsmanship is, if we really want to get to a good decision, to be able to have, I'll say, a level playing field in terms of the information that's being brought to the table is very helpful.
Go ahead, Joe.
Mr. Chairman, if I would, to comment on Mr. Schwab and what he mentioned, I guess, and I was going to bring this up later, I'm very interested in going to observe ongoing operations of charter schools in a very informal way, just to gather information, talk with staff, talk with administration and so forth. And so either, I don't know if that's a decision that the board has to make on the process, if a person can do that individually, do it as a group. But I guess for my own benefit, I think that's really essential, especially as we just get these charter schools up and running, to see the operation and talk with some people firsthand about what problems they may encounter, successes, and so forth. I think that would add a lot to at least my experience and knowledge and so forth.
And that might weigh in where we set a schedule for meetings and we actually visit all of these charters. So good point, I think.
That is true, Mr. Chair, and I would also add that, as I think all the board members are aware, there is going to be the ongoing, or the not immediate exactly, but the urgent need to amend the current existing contracts, not just the transfer today, that's almost ministerial, but to substantively amend them to add some provisions. And perhaps maybe once that's completed would be the time to take up this subject, so that we're not in active contract negotiations at the time. So the sooner that can be completed, I think the sooner we can work on maybe discussion of what the next phase looks like.
Mr. Chairman, Mackenzie, you briefly mentioned conflict of interest as a term a little bit ago. Let me give you an anecdotal case and ask your advice. One of the charter schools uses a program, if you will, built upon Hillsdale College program of some sort. And I think I may have contributed to Hillsdale College very briefly, maybe a one-time deal, solicitation in the mail. Does that give me a conflict of interest if a charter comes up with the Hillsdale model they're using? And if it does give me a conflict of interest, how do I address my duties here on the board?
Well, understanding that we're currently in open session, that doesn't cause me any particular heartburn. I'll say that's pretty attenuated from maybe a one-time contribution to an entity that is, I don't know what the right word is, associated with a charter school. I don't know if they would count as a vendor necessarily, or just some kind of association. That's a pretty attenuated relationship, and so I think we go back to our definition of what is an appearance of impropriety, and would somebody, knowing all of the relevant facts, believe that there's an actual conflict there? With the understanding that it's limited on those facts presented, that doesn't seem to be an issue.
Would disclosure just take care of it?
Perhaps if there was an ongoing concern, but it seems like that disclosure has now been made.
Okay, thank you.
Mackenzie, I don't know how much more you have. If it's just a few minutes, we should plow through. If it's more than that, lunch is here, so you tell me.
I had a lunch break built in, so I had about another half hour. So switching to the specific charter school statutes was the next part of this.
Let's
So
recess for lunch, and I think we have built in 30 minutes for lunch.
I was operating blind, Mr. Chair, so. All right, if you're ready, we'll go ahead and get started. This is the third half of my presentation, as they say on Car Talk. So here's where I'm intending to start to talk about the charter schools statutes in particular for Wyoming. My intent is to give a broad overview. I want to particularly focus on sort of what comes next in this board's decision-making process. The two things that I want to call to your attention specifically have to do with amending the existing charter school contracts to include provisions that were newly added as required terms in the 2023 session. That's going to be the next sort of task. And then the next area of focus that I'm assuming, all of this is of course just what I'm assuming based on reading the statute, has to do with monitoring processes and what the statute has to say about the board's ongoing duties in terms of monitoring. I de-emphasized a little bit the charter application process. I still have that in here so that we can kind of cover it, but that will not be as relevant until the time comes to actually address a new charter application. That's not to say that you can't ask me questions about anything. As we've discovered, there's lots of interest, so I'm happy to pause at any time. So the charter school statutes are found at Wyoming Statutes 21.3.301 through 314. And I have found that the easiest way to, for free, get to see the updated Wyoming statutes are by going through the Wyoming Legislature's website. If you go to that website, you will see in the top corner, there's a drop-down menu. If you select State Statutes and Constitution, you can see a few different things. Feel free to poke around. There's lots of interesting stuff there if you want to see how the gears of government turn, and if you're not already familiar with them. If you select the Wyoming Statutes and Constitution, you'll be taken to a page that gives you a couple of different ways to look at the statutes. My preference is to select the annotated version of the statutes, mainly because I do these for research purposes. Of course, we at the Attorney General's office have a Westlaw subscription, but I try to use free resources as much as possible to avoid using things that we have to pay money for. There's also the text-only version. Those don't have the annotations. The annotations are useful in terms of trying to see what the history of a statute might be and some indication as to when they were changed. If you do select the Wyoming statutes annotated, you'll be taken to a page. You'll have to click off on an I agree box to agree to the terms of service of the website, but you'll be taken to a page that lists all of the statutes by title. Education, generally speaking, is found in Title 21. That's not the only relevant place where you'll find statutes, or education statutes, but that's the primary one. And then you can simply navigate down to 21.3 and then the 300 series. So anybody has any questions on that? So we will start a little bit with the application process. Again, the application forms and timelines are set by the department. And there are certain procedural requirements that the law sets out that need to be followed and honored. So the department does set procedural requirements, but it's within a particular sandbox. It doesn't just get to make up these requirements and these timelines completely out of whole cloth. There are certain processes that are established by the statute, and then the department will make some decisions in terms of that application process within that scope. So some of the procedural requirements, the applicant has to submit a department prescribed application. The application is long. If you've taken a look at the contracts there, we've attached those applications as attachments to the contract to ensure that those promises that they made in their applications are part of the contract. And you will see that some of them are several hundreds of pages. I mean, there's a lot of material there. I don't think these applications suffer from lack of information. Maybe there's some areas that might need beefing up in the judgment of the board in some future application, but certainly the list of requirements is long.
So Mackenzie, in reviewing one of the applications, I noticed that there are statements, "we guarantee," and then they repeat, I assume, the language of the application. Who enforces? Are those things that we need to monitor, those guarantees? What does it mean when somebody guarantees something?
Yes, those essentially are guarantees that they're making as part of the application process, and those, by incorporating them into the contracts, become binding into those contracts. So that would be a part of the monitoring process if their application is approved. So the guarantees that they're making should be carried through, not only just at the time of application, but as an ongoing matter to the extent that they apply as an ongoing matter. It depends a little bit on which assurance we're talking about, but yes, to the extent that they have continuing effect, those are areas that should be monitored.
Following up, then, if we were to determine that somebody had not performed on their guarantee, does that become a basis for revocation of a charter, or does it have to be a material breach of a guarantee?
There's a lot of judgment and there's a lot of play in exactly what the remedies are to any type of a breach. And so out of context, it's difficult to say definitively what that would look like. There's going to be a lot of factors to take into account. I think Claire Vickland, who is a contractor with the department, will be presenting on some of these. And then some of this touches on some of the monitoring duties that you have in terms of being able to revoke a charter. So it's hard to say in general. Some violations might lead to a revocation. I'm speculating a little bit, but I'm assuming that most violations are going to be of the type this board would issue some sort of directive for corrective action in some sense. Revocation is obviously not something that everybody necessarily wants to do, but is usually undertaken in situations where somebody has had plenty of opportunities to remedy the situation, but they haven't.
So you're reading the statute that we have kind of a graduated available set of remedies.
Not entirely. I think that the board can do that, and I'm assuming that the board would want to do that based on other experiences with state government having like licensing type regimes. But obviously that's at the discretion of the board. I would be surprised if the board decided that any violation of their agreement or charter or any provisions of their contract would result in revocation, but that's something that the board's going to have a longer discussion about.
Okay, thanks.
Mr. Chairman, to follow up a little bit on that, now, the application comes in, WDE examines it to make sure that it's complete, then it goes to the AG's office, and then it'll come to us? Is that the way that'll work?
That is not how it worked in the past. There was no role for the Attorney General's office in reviewing the applications, except to the extent that there was perhaps legal advice that was offered while the department was undertaking that review. But I didn't independently look at those applications. The department did, and then asked for advice as needed.
Oh, I see. Earlier, I understood you say it was an automatic, that the AG's office reviewed them.
That was for the contract part of the process. This is for the application part of the process.
Oh,
The contract comes later.
I see. So they're not, the contract isn't formulated until when?
Until after the charter school is approved.
Okay, thank you.
So am I correct to assume that probably the primary or first responsibility of the WDE is to ensure that the contract as it's been, or the application as it's been written, meets all of the education statutory requirements?
The application specifically? That was the situation as it occurred previously. I think with the change in the statute, putting this board, I get the sense that this board is going to have a more active role, and we'll have to take a look at what exactly that looks like moving forward. I believe that it's the authorizing entity that says whether the application is complete, and so that will be this board's determination as to whether applications are complete. I assume that the department will take a first pass at that and make a recommendation and raise any red flags in the application for this board to particularly pay attention to. But obviously, the board's going to employ its own independent judgment as far as that goes. Okay, a few of the items that you might see in section 307, since most of you don't have it in front of you, the things that the application needs to include. I have a few examples here, like a description of the educational program, what the pupil outcomes are that they're looking for, and how they intend to measure those pupil outcomes, employee qualifications for their particular school, how exactly the charter is going to perform annual audits of finances and programs, student suspension or expulsion procedures, that also needs to be in the application, how the charter is going to meet transportation needs, and a financial feasibility statement that shows that the charter school will be viable financially after the first 3 years. So that's just a few of the things that are in the long list that are in section 307. There's quite a few that are there. And there are also some special or additional information or requirements for an application specifically for charter schools that are applying as full-time virtual charter schools and for schools that intend to use education service providers. Those have some distinct requirements. The authorizer, that being in this case this board, determines whether or not the applications are complete. Statute doesn't exactly define what complete is, so there's might be some issues to be worked through in that sense when it comes to particular applications. Once the application is considered complete, the authorizer needs to have a hearing within 60 days of receiving the application, not necessarily when it's determined to be complete, but within 60 days of receiving the application, and then decide on the application within 90 days of receiving the application. As you can guess, it is probably going to be within the board's best interest to decide on the completeness of the application as quickly as possible.
So would an incomplete application be considered an application?
Well, that is difficult. I mean, clearly the statute distinguishes between applications that are complete and incomplete. Like grammatically, it suggests that they are both applications. It's just that one is complete and one is not. Whereas there might be other circumstances in the law, let's say a license application for a professional license that says you need to submit these 3 things to have an application. If you don't submit one of them, then you haven't actually applied. You've just submitted paperwork. So I think the situations are a little bit different based on how the statute works.
Well, as you and I have discussed, I'm a little worried by those timeframes, especially for the existing framework of April being the open date or open month. We could have an application on April 1 that would have to be decided by May 29th, let's say. And we could have an application, maybe a better application on April 29th that we would really not have even considered by the time we have to decide on the first one. And I know that's not likely to occur, but it could. And so one way to potentially get around that would be to have some sort of a deemed application date, that a completed application has to be submitted by a certain date, and all applications have to be in by that one day rather than a window. And there are many other ways we could probably address it, but I've seen where, especially in other contexts, an incomplete filing, for example, is not a filing. It doesn't serve to toll the statute, for example. Anyway, this is my worry there.
Mr. Chair, I think that is an area that the board may wish to address in the future. I don't really have anything without a concrete proposal to necessarily say, but that's an understandable thing to work on.
Is that something we could do internally, or is that something we'd have to be in negotiation with the department on their process? Or can you give us some guidance? Not necessarily today, but at some point in the future?
Sure, absolutely.
Okay.
Mr. Chair, may I suggest that perhaps at our next meeting, that the department take us through a presentation on the process, and then we talk about does this process really fall in line with what needs to happen? And maybe, you know, and I mean, when I talk about a review of the process, I'm kind of talking about the entire timeline of the sequence of steps that needs to happen.
I think that'd be helpful, and whether it's the next meeting or one in the near future, I agree. We should probably know that. Thank you.
Just a thought along those lines, Mr. Chairman. Just what I have seen in the past, I've seen other states set deadlines and realize those deadlines were set at a very difficult time for the schools, right? Sometimes giving them just over 12 months to get a school open, right? So I think that needs to really be on our minds of giving the applicants adequate time. After approval, they have plenty of time to getting all their ducks in a row before opening date, because it's a stressful period. I've been through it. So just something to keep in mind if that's something we're going to discuss is a date, something that's most convenient for schools that do get approved.
Mr. Chair, I think these are all productive conversations. The benefit for in the sense of the current situation is that there aren't any pending applications and you're currently capped. So I think that you have some room to breathe when it comes to working on these issues.
Mr. Chairman, I've got some background noise here that wasn't here before, and I'm having difficulty hearing some of this, but the authorizer determines the application is complete. Now, are we going to have to go through the whole same process that the WDE does when it comes into them?
I don't believe that it contemplates duplicating efforts. So this may be the result of a faulty memory on my part, or it may be a result of a change in the law. I'm having trouble recollecting right now. But this board is ultimately responsible for determining whether it is complete. And I think the department would take an initial pass and make a recommendation to the board or flag things that it sees. I wouldn't consider it an independent review because I don't think that the department, based on the statute as it's currently written, is the one that determines whether it's complete. I think what they can do is help you out in trying to flag things that they think are worth paying attention to you. But ultimately, this board will determine whether or not applications are complete.
Well, I guess I'm just throwing this out as a question to the board. And because this kind of goes into the staffing that we're going to talk about later, but who in the world's going to do that? I mean, how are we going to do that? If the WDE's work isn't acceptable to us and we have to go completely through it and say it's complete after they've said it's complete, I mean, I don't know. I'm just wondering.
Yeah, I wish you'd consider the timeframes in 307 and 308, and I just don't want us to get into a bind where we fail to act timely, or that we, like you suggested, end up duplicating efforts. But it looks to me that we, the board, receive the application, and then we refer it to the WDE for its review. And does that suggest that we don't need to review it during that same time period, or that we are simultaneously reviewing it? I don't know. And then we have certain timeframes that we must take action. We must, within 60 days, do certain things. And then if we fail to act, I don't know what that means. Is it deemed approved? I don't know. So yeah, if you would take those thoughts into consideration, maybe we can discuss them in executive session sometime. Appreciate it. Thank you.
Absolutely. The statute is silent on that point of what happens, but
Maybe we don't need to be in executive session. There is no guidance at this point.
so once a charter school application is approved by this board, now we enter the contracting phase. So this is the point where the contract is negotiated. The process can look any number of different ways. So obviously, to conform to our standard state contracting provision, there's stock provisions that we would like to have included to protect the state, including our sovereign immunity, indemnification, those sorts of provisions that really don't affect the charter school operations any more than it would any other contractor with the state. The rest of the scope really is defined by what are the statutory requirements for what must be in the contract. And Section 305 does lay out what some of the requirements of the contract are. So for example, the contracts need to be a 5-year term. The the contract needs to specify the way that the charter school is going to be held accountable for the performance metrics that it promised in its application. That's going to specify various operating requirements, including those set in the application. And the new thing that the legislature added in the 2023 session was to specify the closure protocols. What happens if a charter school has to close for some reason? My understanding, I am not the subject matter expert in charter schools, but I've had some amount of training from some of my colleagues from other states who are subject matter experts more so than myself. And it sounds like the failure rate for charter schools is fairly high. And so it's probably a matter of time before a charter school has to close, either because it chooses to do so or because it lacks financial viability to continue moving forward or some other reason. And so this provision is designed, in my mind, and reading the statute, to accommodate that possibility.
Mackenzie, when I read that, I wondered what these protocols are. And we don't have much guidance there, but I assume it means how does a student end up going from what used to be the charter back into the district that he or she resides in, or into another environment, maybe a virtual environment of some sort. But do we have much guidance there? I mean, am I missing something on what a protocol looks like?
Not necessarily. This is one of those situations where there isn't any statutory guidance, and so the board is most likely, again, this is just me speculating, the board is most likely going to look at practices that are already existing within the field of charter schools and what seems like prudent ideas. So, for example, there are some obvious things that we need to think about, like records. Where do records go? How do we wrap up the funding? Those kinds of things. There's various pieces out there. Again, I'm not a subject matter expert, but I am aware at least that other states have already specified some of these things. And so that can be a useful starting point. Not that Wyoming necessarily doesn't want to make it, we have our own opinions about things here. But that can at least be useful to inform the board's decisions about what it thinks closure protocols. And I would lastly suggest that, the department is also a resource in terms of offering its opinions and expertise. Again, not binding. The board is an independent entity, but can offer some assistance in helping to identify the appropriate closure protocols. But you are not wrong that there's nothing in the statute.
Okay, thanks.
I guess something, Mr. Chair, to keep in mind, I know that there's a little crossover because these are also nonprofit corporations. So you also have the dissolution clauses of the nonprofit corporations that spill over into most of these charter schools. That being said, they say nothing about public records, or student records of that nature. So it's kind of an interesting area.
Yeah, and that being said, most nonprofits have a clause that says what's to happen to their assets upon dissolution, which we could, in our contract, require what becomes of those assets, which would be funds, but it might be student records, might be computers, might be any number of things.
Perhaps. I do want to point out that a school closure doesn't necessarily mean that the nonprofit is dissolved or stops its existence. So those can be not necessarily the same thing. So there are twists and turns to this whole discussion. So,
Mr. Chairman, is there a date specific that the application has to be submitted by that? I mean, a calendar date? And if not, would that be helpful if we had a date specific when any charter school applications come in that we want to, start up in the next 12 months or at 15 months or whatever, that's the date they have to have them in?
Well, I think that gets to the idea that the WDE will come in and present to us the process. And right now, as I understand the process, they file in April. Is that correct, Elaine?
Mr. Chair, actually currently in rules, it's July. And that was because of the way, because of the way the timeline fell last year with rules.
Okay.
But we are in the process of revising those rules, and we can certainly look at that date.
So
That was
July would
something
be
that
for
we've-
14 months in advance of opening? Is that what you're saying then?
Well,
Roughly?
it would have been less than that. Well, yeah, you're right, 14 months.
Roughly.
Yeah.
Not 2 months.
No, and I think, Mr. Chair, the other issue was that once the SLIB heard it and the contract was actually executed, it was actually February. So Mr. Schwab's point about, not having an entire year to really set up and get ready to open has, I think, been a challenge.
Well, I think this board will want to have a voice in that process. Is that fair? We've got some experience that I think will be helpful.
Yeah, and because what I was really thinking about, Mr. Chairman, was whenever the clock starts ticking.
Exactly. I'm worried about that clock too.
Yeah, thank you.
Well, Mr. Chairman, I just, again, want to highlight some of these timeframes are statutorily set, so there's really not much discretion that this board is going to have without a statutory
Yeah,
change.
and that bothers me too, because we could have an application tomorrow. And what would we do?
Right.
I don't know, just yet. Anyway, go ahead.
We will move on to application review, and I put revocation also in here in terms of the process. So this board needs to review charter school applications and make a written determination on the application. So that kind of gets to your point. I'd forgotten this when we had our previous discussion, but there must be a written determination, whether it is positive or negative.
A written determination might be, we approve or we decline.
Certainly.
It doesn't necessarily mean that there's reasoning attached to it, does it? Or do you infer that from the language?
I don't know that I infer that from the language, but I will tell you that's what I will ask for, is reasons. Reasons are, in my world, are very important. So the statute does provide a couple of benchmarks in terms of approving the application. There's not much of guidance, but it does offer these. It specifies that the board should grant charters to applicants that possess competence in the elements of the charter application requirements. I can't tell you necessarily, practically speaking, what that means. And so I think that's another area for the board to think about what exactly that is oriented toward. And then the second specific item that's articulated in the statute is that the board should base its decisions on documented evidence collected through the charter application process. Which kind of gets to the point that we were talking about earlier about, while there's an application pending, going and having some extracurricular activities to view the charter school or to do additional, as I think we've already established, it's a difficult line to draw when we're talking about what the decision should be based on. But generally speaking, the statute says documented evidence collected through the charter school application review process.
So this is mandatory. We shall grant a charter in these instances. Does documented evidence include testimony at a hearing? Or is it something that the testimony can only be used to explain a document that's before the board?
I would suggest that anything that would be characterized as a record would probably qualify as documented evidence.
So that would include oral testimony.
Precise, as long as it was, in theory, you would want to make sure it was reduced to some sort of physical form, but you would want to do that anyway.
So it would behoove us to capture any key things that were represented to us upon which we based our decision.
That is
in
correct.
the decision letter, I think that you're just.
In the decision letter and in the administrative record that would be put before a court in the event that we ever get a challenge, Absolutely. And it's not that dissimilar from what our office recommends during rulemaking hearings, for example. We typically recommend that there be a court reporter to accurately capture the comments that were received during those rulemaking hearings. Those of you who are familiar with this process will know what I'm talking about. But
Okay, thanks.
in terms of application review and revocation, the areas that you're charged with making decisions are on renewal, non-renewal, and revocation of charters granted by the authorizer. So, it's worth noting at this time that there's a lot of monitoring activities, and certainly you can tell the charters, here's what you need to do. The actions taken are, or the only sanctions that is explicitly mentioned in the statute is revocation. And I do want to note that these standards that we're talking about all tie back to that application and what's required to be in the application. And now getting into ongoing monitoring. This board is charged with monitoring charter schools that are approved by you. You have to establish and maintain, and this is where we get into the distinction between rules and policies. You have to establish and maintain policies and practices consistent with the principles and professional standards for authorizers of charter schools, and specifically related to the following things that are listed, which I'll get into here. The one thing that I want to note is that there's no real clear indication of what professional standards means. I am aware that the National Association of Charter School Authorizers does have some sort of issued professional standards. That doesn't necessarily apply, but this board might borrow from it or use it to the extent that it finds it useful. So that's one source. There could be any number of other sources from which this board could derive professional standards for charter school authorizers. Some of the policies and practices that the statute specifically calls out, requirements for organizational capacity and infrastructure of the charter school. Infrastructure can maybe mean a few different things. So I think part of that obviously is facilities, but it could also be other forms of infrastructure in terms of knowledge base and those sorts of things. How to solicit and evaluate charter applications. So this is the process that you're going to use when you're actually doing the evaluations of the charter school process. And notice it says solicit as well. So, to the extent that this board has, and let's call it an open slot or an availability to approve a charter school, you should probably have some sort of established policy to show how you're going to promote that, advertise that, make the public aware that that is available. You should create policies and practices for ongoing charter school oversight and evaluation. Some of you may be noting that there's not a whole lot of detail there about what oversight and evaluation means. That's correct. The statute empowers the board to come up with what that looks like. Obviously, there are going to be some limits there, but it's a pretty broad mandate in terms of policies and procedures. And then the charter application, approval, renewal, and revocation decision-making. This is how you're going to make those decisions procedurally and I think substantively. So there's a lot to unpack with any one of these. I suspect that you could probably spend a good 2 hours on each of them and still only scratch the surface of what that's going to look like. And I also suspect that this is going to be a very fruitful area for committee work in the future.
So we know that there's a need to amend all the charters. And specifically, one charter is, I think, appearing and asking for a change to certain dates.
Correct.
Does that constitute a renewal or an approval? Or is that something separate and apart that we have authority to do?
I think that is separate and apart, and that's inherent in your authority essentially as a beneficiary of that provision of the contract. It's more of a contract term than anything else.
And the contracts do anticipate amendments that are mutually agreeable to the parties.
They do, yes.
So I just wondered where our authority came from. And I guess it comes from our contracting authority.
That's exactly right. I wouldn't consider it to be an approval because I read that to mean initial approval. Renewal, which would be ongoing approval or renewal approval. And then obviously revocation, different kind of decision, revocation. So I think that the contract, just as a contracting party, you have the authority to waive a provision that is in your benefit.
Okay, thank you.
A few other relevant provisions that I wanted to specifically bring up, not that these are anything that you necessarily have to deal with today, but they are going to be topics of discussion at the very least. So the first thing I want to mention is the statutory mandate that this entity act as the local education agency under specific circumstances. So for those of you who perhaps, I don't know that there's anybody here who is completely foreign to education, the education world, which is probably good. But local education agency is a term of art that's used primarily in federal law when we're talking about a unit, a granting unit. And what I mean by that is the state agency is typically a state education agency. They receive grants of funding from the federal government, and then they subgrant those typically to local education agencies. Of course, I'm glossing over a lot of nuance and detail, some exceptions and some twists and turns, but that's the basic structure of how that generally works. This provision in the law says that this board will act as a local education agency in order for the charters to receive federal or state grants that require a local education agency to apply. So basically what that means is that for certain purposes, this board will be in the same position as a school district. There's a lot of implications of that, which I'm sure are running through all of your heads right now. Again, we could spend an awful lot of time unpacking a lot of that, some of which I'd want to do in executive session. But there's a lot there.
And you assured me that we're indemnified by the state when we had a private conversation, as long as we're acting within the bounds of the legislation.
When you're acting within the course and scope of your duties, yes.
I think, Mr. Chairman, I think that's kind of interesting, just where they have local boards for their school, which technically kind of operates like the local little school district, but yet, we're the LEA, local education agency for them. I just find that kind of interesting on the terminology. But
yes, I think that this will be a particular area of discussion when we start talking about special education in particular, to the extent that there is a special education allocation made to the charter schools through this board. That means that the accountability for complying with the IDEA requirements will lie with this board. And so that's a longer discussion to be had. One thing I did want to point out is that the state law does specify that this board will act as a local education agency. It's not entirely guaranteed that for every single federal grant that's out there, their definition of local education agency will align with this board's characteristics. What I mean is it's all fine to apply the label local education agency at the state level, but if the federal government says this is a local education agency and it requires these things, and this board does not have those things, that wouldn't mean anything. So you would still not be eligible for those federal grants. If that situation arises, we can talk through that. Right now, I'm not aware of any specific example where that might occur. Board funding. This is an area that's not within your authority, but it's something that will come up, and it's useful to have at least a basic working knowledge. Well, I'm sorry. Charter school funding is not within your authority, and we can talk about that to the extent that you want to. I don't have it as part of my presentation, but we can certainly discuss it if you want to get into it. This is actually just about the board funding. So the statute says that the board may assess administrative fees up to 3% of the amount of state funding that the charter school receives. Specifically, that's guarantee funding, not necessarily all sources of state funding. So as some of you know, the charter school, and I'm vastly oversimplifying this, but they receive an amount of funding that's essentially proportional to the amount that's generated by the average daily membership of their students. And so this board has the ability to assess an administrative fee of 3% of that total amount, up to. It could be smaller. You could choose to assess only 1% or some other amount.
Mr. Chairman, I have a question regarding the funding. What is the funding, I guess, typically at right now per ADM for a charter school?
That is beyond my knowledge base. I'm vaguely aware of what the statewide per pupil funding is, but that's not really a meaningful number because the way our funding system works is there are so many things that alter that depending on the number of schools, the grade levels, there's tiers depending on whether it's a small school or a medium school. I don't have the answer to that. I anticipate that we will have somebody from the department's operations unit who might be able to answer that, but I'm not going to speak on their behalf.
I just think it's probably something we ought to consider, when moving forward, when discussing the administrative fee, because if it's up to 3%, I know that, I guess on average across the nation, they receive significantly less than a traditional public school. I'm not sure on where that's currently standing right now, but it's just something to consider on what type of impact it could have on charter school operation. Not sure. I guess is that something that we need to decide as a board of up to, and what that number is going to be, what it needs to be?
I think we will at some point.
Well, that depends on you. This is my last slide, but it depends on how long you want me to talk here and what you want to ask me about. Okay.
And I should activate my microphone or Elaine will be very upset. Sorry, Elaine.
Mr.
Doug?
Chairman,
Yes.
I want to thank McKinsey, outstanding. And I've learned an immense amount, and I'm sure our whole board has, and this motion isn't meant to cut you off. It's just the clock is ticking. And because of, we have some board members that absolutely need to leave at 3:30, Mr. Chairman, I'd like to move to amend the agenda. And on page 2 of the agenda, I'd like to move that item up next, which is the transfer of authority from SLIB to us and the contract amendments. And then the next item to follow that would be the Cheyenne Classical Academy. And then the next item of business after that would be your appointment of committees, if you're going to do any.
And then that would be the end of the meeting?
Pardon me?
And you would then suggest we'll be at the end of our time?
No, I'm just suggesting we get those out of the way to make sure we don't run out of time for those. Because the training parts of this are very important, but those are things that we can do at the next meeting.
So let's handle these one by one. Without objection, let's move to the transfer authority from the SLIB to this board and contract amendments, which might mean, McKinsey, you're back in the hot seat. If that's okay with everyone. Any
I
objection?
think the motion takes a second and a vote.
Let's just do it without objection at this point, because I think we all understand yeah. Okay. So can you speak to us about the transfer?
Certainly, Mr. Chair. The recent amendments to the charter school law that created this board also dictated that the responsibilities for contracting with the charter schools should be moved from the State Loan and Investment Board to this board. And it specifically said that that should happen through amendment. And so that is all this is intended to accomplish, merely moving responsibility from the SLIB to this board. It is not intended, and it does not change anything substantive in the contract. That was to be reserved for future action and negotiation on the part of this board. It is meant only to transfer the party position from SLIB to this board.
Mr. Chairman, I move.
Second? Anyone second? Fred's desperately trying to second it.
I'll second that.
That being said, discussion on the motion, which is to accept the transfer. Janine, you had your hand up?
Thank you, Mr. Chair. I'm trying to find it in I believe that this requires changes to the existing contracts. Because at the present time, this puts WDE, help me with the language, I can't find it, puts WDE as the responsible party because the SLIB board did not have the skill set to do this. And so does that change within the contracts that have been submitted so that this board is responsible for the oversight?
Okay, I think you're referring to paragraph 5, responsibilities of the board, which.
What page are you on? Do you know?
4 of 12, which was the contract that I think was common to all 3 of the authorized charters, which said, in accordance with the statute, the board as authorizer authorizes WDE as its agent for purposes of monitoring the charter.
Agent is the word I was looking for.
Okay.
So does that not need to change in in these existing contracts? Because is the WDE still the agent?
So let me, Mr. Chair, if I may, explain that. So the Department of Ed was never a decision maker when it came to the charters. It was always acting as an agent of SLIB, with SLIB being the ultimate decision maker. That was the entire purpose of that. That does not change with this contract transference. If that's something that this board would like to reconsider, that's certainly a discussion that could be had. But our goal was simply to switch out SLIB and this board. And by designating them as an agent, that doesn't mean that the department is empowered to make decisions like, revocation of a charter or anything like that, issue corrective actions, those sorts of things. Those would always still come to the authorizer, previously SLIB, and now this board. So there's no concern that I would necessarily have about them being the agent. This board is still the authorizer and is still responsible for making the decisions relevant to those charters.
That wasn't, thank you, that really wasn't my point. I just, when I reflect back on the language and how we got to where we are with the department being the agent, things are different now. And I'm just asking the question if that needs to be changed in the contracts. WDE did a wonderful job and I have no issue with that staying. I'm just asking if because of these changes, that should change.
Sure, Mr. Chair, if I could address that more specifically.
Sure.
I don't think it needs to be changed. If this board would like to reconsider or do something differently in the future, I think that's certainly an option that's available, but I don't think that there's any necessarily a legal need to change it.
So as I read this, it would require the school itself to approve that amendment, though. In other words, it would not be something we can do unilaterally. Is that how you read it as well?
Yes, so this is an amendment to the contract, which requires all the existing parties to also agree to it. My understanding is that SLIB approved its amendment today, this morning, and I'm not entirely sure. Elaine can speak more as to where the charters are at, but I understand that I believe that they've been sent this agreement, but they haven't maybe executed it yet.
Well, so, and I don't want to be hyper technical, but typically a principal, in this case us, can terminate the powers of an agent unilaterally. It does not require the approval of a third party. And yet this might be our one chance where the third party would gladly consent because they want something else. They want to remain in compliance with the law. So I think where Janine is headed is, should we be considering this at the same time? And should we, I'm not saying we do want to change the agency relationship, but I don't know either. But is it something that we need to take up in this moment?
Mr. Chair, if that was the board's wish, then we would have to redraft this amendment. I guess I don't really have an opinion on whether the board should undertake that process. All I can really say is that what it would take to accomplish that would be to go back, redraft these amendments, and then bring them back before the respective boards a second time.
Well, I think we need to do at a minimum the substitution of this board for the SLIB. Beyond that, I'm not sure what the pleasure of the board is. But it seems to me that this is also, they're part and parcel of the same thing. And so it concerns me a little bit that we haven't had a chance to consider that. And yet I think we need to move forward. We need to respond to the action the SLIB took today, and more importantly, report that back to the SLIB so they know they're out of the equation, and possibly to the legislature. But there may be other things we need to change in the future. And as I read it, that requires the consent of the school itself, the applicant. So I don't know where people feel on that.
Mr. Chairman, I defer to our legal counsel and just tell us what we need to do so we can move on.
Well, there are some policy implications, I think, to the idea of, do we continue with, the department as an agent? I'm not sure what other alternatives there would be at the moment, regardless. So for various reasons, I think my recommendation is to approve it as given. But I want to make clear that I'm not trying to suggest any particular policy direction in the future. The point is to simply accomplish this one part and then take an evaluation of what other policy decisions need to be made.
Well, as I read the statute, others can read it as well. The department creates a liaison, and then we can request certain things of the department. And that's not an agency relationship. That's a relationship where we make a request and they conceivably could say no. And yet this is different. This is an agency, which means they have a lot of authority on behalf of the board. And maybe that's what we want. But at this time, I don't know that it's been considered by the board that we want to defer that power to them.
Mr. Chairman, I
Cindy.
absolutely think we need to move forward because we don't have staff, we don't have a
That's true.
budget, we are operating where right now, perhaps again, this might be one of those topics as we get into this a little bit further that we might want to review our position on that. But for today, I think moving this forward and leaving things as is and essentially just switching us out for the SLIB might be the best course of action to kind of move us forward.
Okay, so maybe the course of action would be when we present the amendment to the three applicants, that we also inform them that there may be additional changes we'd like to consider, including, we know that the statute now has been amended that the school closure protocol has to be in place. And that would be one of maybe 2 or 3 others that we want to consider. Just alert them so that we don't surprise anybody. Does that make sense? I'm not saying we will make changes, but maybe changing how we think of the WDE in the role other than as an agent and more as a liaison and a service provider is something we should communicate to them.
Mr. Chair, I am aware that they are at minimum aware that amendments need to be made to conform to the change in the law. And presumably the department can ensure that communications occurs in terms of others. I suspect that the news may have already broken about your suggestions. So.
Okay, well, let's go ahead unless there's other discussion. Should we don't have a secretary to read back the motion. Maybe Elaine is the secretary.
Mr. Chairman, I couldn't quite sort out all the legalese that was flying around here, but back to my farm boy mentality, if we don't do something with this amendment, I don't think we can make any other decision today because we haven't officially become the board.
Okay. And your amendment, I think, is just to substitute the parties, right?
I didn't make that as.
We would substitute this board for the SLIB.
Mr. Chairman, I move that we substitute the Charter School Authorization Board in place of the SLIB Board.
Okay, so that's two motions. If that's okay with you, Doug, we'll take up Cindy's motion.
Absolutely.
Okay. And I think, Fred, you were the seconder.
Oh, Fred, second, okay.
Yeah. You're okay with that too?
Yes.
Okay. Any further discussion?
I didn't mean to postpone that.
Come on, Alice. All right, all in favor of the motion, say aye. Aye.
Aye.
Any opposed, say nay. Motion passes.
Mr. Chairman, the next item that we moved up, yeah, I know. I'm trying to think how I want to say this. I'm going to defer to you, Mr. Chairman, how you want to approach it. I was going to make a motion, but I'll leave it to you.
So I think the next item on the agenda is the request of the Cheyenne Classical Academy to defer, which maybe we ought to hear from them and then make a decision on how to proceed. Is that okay with everyone? And I think there are folks here that would like to speak with us, including, I see Nathan coming up this way, and Representative. So, and I don't know how much time you plan to, we're trying to be expeditious here, so thanks.
5 minutes.
5 minutes, perfect. Okay, we like that. Thank you.
Always be careful when a lawyer tells you it'd only be 5 minutes, but. Well, my name is Nathan Winters. I'm the chairman of the board of the Cheyenne Classical Academy, and with me is Representative Jared Olson, who is my vice chairman on that board. And it's been a privilege to be able to talk to you a little bit today about the necessity of a deferment letter. We did notify the State Loan and Investment Board just a couple of months ago that we would not be able to open this year before September 5th, 2023, which was what the charter would ask for. We had almost everything in place last year whenever we were able to give our case to them and received unanimous approval to move forward. There were two things that we needed. First of all, we needed a headmaster, and secondly, we needed to secure our location. We were able to find our headmaster. Of course, we even had someone kind of in line to do that. We just were waiting for the charter letter. The second thing is we had the opportunity to look at several different locations across the city of Cheyenne, and we had secured the help of a wonderful real estate developer to look at what was available. We were able to look into a facility on Ridge Road. But as we looked further, with the assessment, we weren't able to get into that until August the 19th of this year, with, of course, school needing to start the following week. And even that couldn't be fully guaranteed because of a couple other circumstances. We were able to develop a conversation with the legislature and look into a facility here that was vacated by the Laramie County School District number 1. At least at the time, there was still some future things that they might want to do with that facility, but it will be empty this year. That, due to circumstances beyond our control, was something that wasn't something we could take advantage of this year, and I think that is being rectified now. But in the meantime, we have been able to go back to that original facility, the Ridge Road facility. We've already placed our money down and are moving forward. It's under contract, and so we're able to continue moving forward. We just need a deferment for 1 year until 2024. And our vice chairman may also have some things to add.
Thank you. No, I think you covered it pretty well. I would certainly be open to any questions, though.
Questions from the board? I have a few.
Yes, sir.
I assume that there were, and this is perhaps incorrect for me to assume, but that there were students that hoped to start September 5th. What's the status of those folks and their parents?
Yes, sir. So we had up to 200, but when that were interested, about 128, I believe, something around that, had fully gone through the process and were ready to go. Those are things that right now we're still kind of in flux, just saying, please hang on. We're hoping to start up next year. So right now we're not exactly sure where those numbers are, but we're fairly certain 100% certain that once we're able to demonstrate that we have the facility and still have our headmaster, the program that we are opening up with is something that really is compelling in the community.
So those students do have a place to start school here in a few weeks, correct?
To my knowledge, yes, sir.
Other questions? Joe?
Mr. Chairman, so a question, and from my own basic knowledge too, I know other districts across the state are struggling with staffing. And so I'm curious to hear from you about your experiences with trying to get staff and what that's been like. But then also with delaying an opening, if you had staff either under contract or promised jobs and so forth, how is that going to be handled? And how will a year later affect staffing for instructors and teachers?
Mr. Chairman, through you, this was one of the amazing stories for us. We had a lot of people reach out of their own volition to look for the opportunity to work with us. They were very excited about what we were having the opportunity to start here in Cheyenne. That was one of the reasons why we went ahead and asked for a deferment letter. Until we could get a facility squared away, there's a cascading effect with bringing them on board and then getting them trained up. We actually, Hillsdale College works to get them out to Michigan to go through a training and everything else. And so that staffing piece, we were having a lot of response there, but that was one of the reasons why we felt it would be important to send that deferment letter in when we did.
Question I have, when you talk about deferment, do you want an extension of the 5th year, or are we now talking about operating for 4 more years? Is it an amendment of the
Well-
duration, or is it just amendment of the starting time?
Yeah, Mr. Chairman, we would take either or both.
Yes.
I think if you wanted to keep all 3 charters on the same level so that the ending date was the same, we would understand that. We would have only the 4 years, but 5 years is what is contemplated by the statute initially. So we would definitely take an extension of that if you would consider that.
Yes.
Go ahead, Cindy.
Mr. Chairman, I think that we absolutely should consider trying to maximize the time to allow some of these pieces to come together and to provide additional staff training, as you mentioned. I just really feel from my perspective, having as much time to give you that opportunity to be successful is a benefit to ultimately the students. So that's my thought.
Yeah, Mr. Chairman, I do know, at least from what I've seen, it would be, I guess Mackenzie can pipe in, I know it would be a little bit more complex if we were to say, hey, year 1 starts next year, because I think that would require an amendment to the charter agreement. Am I correct? Because it has a start date and a renewal date. And so I'm assuming that would be the case unless we were to say, hey, the charter application will simply be amended to where you're starting on year 2. I've seen that happen, but then you have different enrollment numbers that pop up on that year as well, typically. So just something to consider. But
Mr. Chair?
Mackenzie?
Just to clarify, kind of based on that question, if this board so this board can waive a provision in its benefit, that is to achieve the sort of 1 year or other time period delay without necessarily amending the contract, a change of the termination date would require an amendment, but we're already contemplating amendments anyway. That might be the time to establish what the scope of that amendment would look like, since we're already going to have amendment conversations anyway.
So maybe Mackenzie or maybe you, Nathan, can answer this. I think what your concern is, as you're here today, is that you don't want September 6th to roll around and be in default. And to have this board or somebody say the charter should be revoked because you're in default. And if we could provide you some comfort in that space, and I'm now speaking to Mackenzie, would that allow us as a board to, I mean, it's a fairly long application. I didn't get all the way through, but I got 100 or plus pages into it. I don't know if everybody else had a chance to review it. If we came back in a couple of weeks and we've all had a chance to consider it, and we've talked with our attorney about what other amendments might be appropriate, Would you be okay with that, or do you need a decision today?
Mr. Chairman,
Jared.
we would really strongly prefer a decision today. The moving forward with the real, right now, our entire world is paused because everyone that we're working with says, well, we have to wait until this hearing to see if you get the deferral. So the biggest pause there is our real estate. And in order to move forward with real estate, we have a lot of renovations that have to occur. We have to go through planning and code and all of that compliance. And that's the problem we ran into last time, was trying to get the renovations done in time before the fall startup deadline. So I think we would really prefer a deferment today.
Well, I don't know what the rest of the board members feel about taking action. Maybe everybody's read it. Well, maybe I'm the one that didn't read it all the way to the end.
Well, Mr. Chairman, I can certainly empathize with you. When we were looking at the CTE charter school in Natrona County, one of my big concerns, having a lot of experience in the construction industry, is looking for a building. And even if you find a suitable building, then again, trying to remodel and make it suitable for students and so forth. There's labor shortages and trying to work with contractors. And so I guess I'm of the opinion that, those are things that are just as hard as you try, that are really outside of things that you can really control. And so I guess my thought is that you shouldn't be penalized for that. And you're trying to move forward, but you have people that need to know what the next step is, and things are getting right up to the starting line as far as securing a facility. And to me, that's going to be a huge piece for charter schools now and in the future.
And I think, Mr. Chairman, just to, give you a little comfort, the initial application was unanimously granted by the SLIB board, and I know you are your own authorizing board, Mr. Chairman, but to give you a little comfort, that was a thorough process where we were vetted for an entire day, and then the unanimous decision came through. So not that you shouldn't review the application, but it's kind of where we stand is we feel like we had that hearing and we went through that process.
And
Well, I was just going to ask if the board had other questions, but go ahead, Nate.
Mr. Chairman, I think your assessment, the way you phrased it at the very beginning, having the deferral granted today would truly help us, not only with the real estate piece, but also we have had the opportunity to work with others to help fund our headmaster until the charter is in place. And there are several talks kind of waiting on today so that we can continue moving forward. There are two pieces that need to happen at the same time. One is the real estate, and the other is securing the help of a headmaster. And so today would be best for us if we could work toward a deferment today.
Go ahead, Mitch.
I guess for the board, the thought I'm having is that we go ahead and move forward with the deferment with a start date of next year in accordance with the current charter application. And then if they want to come forward soon to amend their agreement of changing the termination date, when we have to amend charters, they can do that at another time.
That was going to be my suggestion too, Mr. Chairman.
Any other comments, Fred?
Yeah, Mr. Chairman, I was thinking the same thing. It has already been approved, and I think we're going to have a lot of work to do to work on policy and practice, and that would really slow them up since it's already been approved. Unless we had a compelling change that we think we need to make, I would be supportive of verifying that we feel comfortable with the go-ahead and just make that decision.
Janine?
Well, thank you both for being here. I know you both quite well. I know your intents are well intended. I just don't want to have the kiddos not have a smooth transition to start school in September 2024. Make me feel better about, is there something we can do, or is there something that needs to be done to help you get the permits and the whatever you need in order to move forward, excuse me, with the renovations?
Mr. Chairman, through you, Ms. Teskey, I appreciate that very much, and you're absolutely right. I think that the deferment right now is really the best step to move forward. And that's the reason why we wanted the deferment. Rather than trying to shove everything through this year, we felt it would be best to truly have a beginning that was really excellent, and that can happen next year.
we don't have a motion pending. Fred?
Thank you, Mr. Chair. So outside of, it sounds like your contract is in place. You just need more approval for that for the school system on Ridge Road?
Yeah, there's several steps that have to occur. We're working with a company who actually is the purchaser of the property. That company is already under contract. What the next step will be is a lease, where we lease it from that company, and we can't move forward with that step. That's step number one until we have the deferment. But we are, in sum, we consider ourselves under contract through that part.
Thank you. And are there any other stipulations of the application that are in question today?
No, that's if there's anything that's different from when the last time we appeared before the board asking for authorization to today, it's the fact that we actually have our real estate secured.
Thank you.
Mr. Chairman. Mr. Chamberlain.
Mr. Chairman, I have a gnawing feeling that from the business world that I would never agree to buy into a business if I hadn't had a chance to look at the books. And I feel like in this case, we're kind of there. I don't know, Fred or somebody just said it was approved previously by the SLIB board, and they're much more intelligent than me. So I was prepared to vote no, but I'm going to vote yes. And Mr. Chairman, I call for the question and ask for a roll call vote.
So I don't think we have a motion on the table.
Mr. Chairman, I was getting there. I move that the deferment be approved as presented and requested from the Cheyenne Classical Academy today.
And by that, do you mean 1 year?
Is that the request? That's 1 year?
Yeah, fall 2024.
Fall 2024.
Okay.
And
Second?
I would second that motion.
Joe, you wanted to say something?
No.
Okay. Is there a need, or do we want to accept any further testimony from anyone else? Is there anyone in the room that wants to talk about this? Then is there any further discussion?
I just have one, I guess, a comment, and I don't know if hopefully this is good advice for you, but I was involved with opening a new program and so forth at my current school district that I retired from, and they struggled. And the best analogy, I think you're wise in doing this, and the best analogy that I can give you and other people in the room as well, it's opening a school is so important to make that first good impression. And so it's like going to a restaurant, opening for the first time here. If you have a good meal, good service, good staff, it's clean, people will be back, and the word will be out, especially in small towns like Wyoming, and knocking on the door to get in. On the other hand, where we struggled, if students and parents have a poor experience, you will struggle. And they have slowly, it's taken several years, climbed out of the hole and now have some very, very viable programs. But it was a struggle. And so my advice to you would just try to do the best you can on that first opening day. And it sounds like you're off to a good start. Make that good first impression, and you'll be well on your way to being successful.
Further comments? Doug has called for the question, and I think you wanted a show of hands or roll call. Okay, let's have a roll call vote. Lane, can you take care of that for us?
Yes, Mr. Chair. Mr. Chamberlain? Ms. Delancey?
Aye.
Mr. Filer?
Aye.
Mr. Masters?
Aye.
Mr. Schwab?
Aye.
Ms. Teskey? Mr. Von Aaron's?
Aye.
Okay. So I think the next step will be for our attorney to prepare a document that we sign off on that does this and gets it approved by the contracts unit. Maybe. But anyway, at some point I'll need to sign something, and I guess somebody on behalf of the school will sign something.
Mr. Chair, this is simply a waiver, so no contracts unit input is required.
Okay.
Good luck to you.
Yeah.
Thank you all.
Yeah. Okay, thank you. I think the next item that that Doug suggested we take up would be whether there should be committee appointments. And the discussion earlier today was that whether we needed committees and what those committees would be. Do we want to take that up now or handle that at the next meeting? What's the preference, Doug? I mean, you've got reasons for what you suggested.
Well, I don't have that piece of paper. I don't know if you sent that to me, but there were 2 suggestions for committees on there. And I don't remember how they were split out, but I do know one of them was on our parliamentary procedure for our upcoming, for the future meetings, which in my opinion, we really need to get established if the other board members feel the same.
Mr. Chair, if I could just interject, you may recall we had the discussion about adding that. I will say this, I think that since parliamentary procedures was within the scope of what was noticed, that I do think that that is probably fair game to appoint a committee, given that the subject of parliamentary procedures and the board's adoption of those was on the agenda and properly noticed.
Could the committee that takes that up also make recommendations to us concerning the establishment of other committees? Would that be appropriate, or would they be limited only? Because in parliamentary procedure, usually you anticipate the creation of standing committees.
I think that the charge that the board wants to give could add additional topics onto the parliamentary procedure if that's the board's wish.
Okay. Well, first, is there any objection to going that route? What I would suggest is if we go that route unless there's objection, and then I'm going to ask for volunteers to serve on that board or that very informal committee.
Mr.
concerning
Chairman, I'm
parliamentary
confused on, we need a committee to examine parliamentary procedure for how this board, I'm confused on
Okay.
the necessity of a committee.
So the motion we adopted was to incorporate Robert's Rules of Orders. And Robert's Rules anticipates you can make deviations from that. And so this committee would look at whether deviation of any sort would be needed from the standard Robert's Rules of Order.
Mr. Chairman, and I don't know if we have a record of this or not, but my motion originally was for us to come up with an abbreviated adoption of the Robert Rules of Order, not the hard and fast.
That's correct. I was a little bit verbose, sorry.
Okay, so the purpose of this committee is to determine what that abbreviation is. Okay.
So first, should we vote on that as a motion? Shall we create a committee to review an abbreviated set of Robert's Rules of Order?
Some of,
Second?
I'll second that.
Any discussion? None appearing. All in favor, say aye.
Aye.
Any opposed, say nay. Okay, now I'm going to ask for volunteers. And Doug is a volunteer. Cindy's, and Doug and Cindy, maybe, does anyone else want to, we just can't become a quorum, so we're limited to 4. Anybody else? Okay, Mitchell will join you, the 3. Okay.
I've got a daughter that's a veterinarian, but not a lawyer, and I'm smart enough to defer to my lawyer friend here.
Okay, all right, so those 3 individuals will report back to us at our next meeting. Okay. We had jumped ahead on our agenda. Is there anything else you feel needs to be handled in the limited time we have left, Doug, or anyone else that we need to move ahead on?
Well, Mr. Chairman, by my motion, the next thing would be budget explanation. And we're, for the ones who need to leave, we've got about 25 minutes left.
And I think it's pretty important that we discuss a meeting schedule so that, for example, Professor Buss was not able to be with us, but had he been provided adequate notice, maybe that would be different. So budget explanation, it looks like that was Trent. Where is Trent? Oh, there he is. He's here.
Good afternoon, Mr. Chair. Can you hear me okay? Can you give me a thumbs up? You can hear me?
Yeah.
Awesome. Well, I apologize. I couldn't make it there in person today. Fell victim to a stomach bug over the last 24 hours and didn't think it would be good to share that with anybody else. But happy I can join you through technology here for a few minutes this afternoon. It sounds like you have a limited amount of time there for at least a couple of your members. So maybe I'll just follow your direction in terms of what you want me to cover. What I had planned to cover was just a quick overview of the appropriation that was included in the budget bill. And then during the last session, and then just some logistical pieces on the meeting expenses, travel, per diem, salary, those types of items. But I'd be happy to amend that to kind of shorten it up if that's the pleasure of the board.
Yeah, if you can shorten that up, I think that would be great. Thanks, Trent.
Okay, you bet. So we'll start with the appropriation. So the Department of Education received $280,000 in a budget bill footnote during the 2023 session. It's footnote number 6 in section 206. That's the Department of Education's operational section. We also have another agency 205 where we have all of our school funding, but the legislature added footnote number 6, which gave us one full-time equivalent position and $280,000 for fiscal year 24. The legislature also included some language in that footnote that basically indicates the intent of the legislature is that that same level of appropriation be sustained going forward in the Department of Education standard budget. So what that means is we have $280,000 for the first year, and then we have $280,000 for the next 2 years. So it's a little bit of a front-loaded situation there. So we do have the one FTE position that will be providing support to the board. And so we're in the process of filling that position. And so we would need to basically assign the amount for payroll that we would need for that position out of that 280. And then originally we had estimated some amounts for equipment for members, of course, meeting expenses for board member salary and per diem, some other small items like phones and IT items, supplies, and then travel for the WD employee that would attend the meetings. So for the first year, so just keep in mind that these numbers are estimates. And so as everything comes into focus with the number of meetings and the location of those meetings and other things, some of those estimates might change, but there would be about $120,000 roughly that would be discretionary for this first year after we've accounted for the estimates, those placeholders that we came up with. And then for the next 2 years, just a little bit of information for the board. We are currently in the process of developing our BFY 25 or our 2025-26 biennium budget request. We will have that wrapped up by the end of this month. And then we'll move forward through the regular process where we present that to the governor and then to the Joint Appropriations Committee. And then it moves through the regular legislative process. But for the next 2 years, like I said, the current appropriation is set at $280,000. And so just the position funding alone uses up most of that when we account for salary and benefits. And so that brings us to, I think this was mentioned a little bit earlier, but there is a provision in the law that allows up to 3% to be recovered in administrative fees from the charters. And so that's, I think, an important point to consider how you want to manage that. And if you were to collect additional revenue, we could, of course, look at that going forward and factor that into the operating budget. So that's kind of where we are with the appropriation. I'll stop there and see if there are any questions.
Well, I'll ask the first question. Do we have any idea what 3% of the charter budgets will look like in a year or two?
Yeah, that's a great question, Mr. Chair. And unfortunately, today I do not have a number for you, but I will have a better idea very soon. We are currently going through a process that we have to follow whenever there's a legislative change to the funding model. We have to go through a technical correction process where we basically incorporate the changes into the model and then have the changes reviewed and independently certified by the Legislative Service Office and their consultants. And we're hoping to hear back any day now on that. And then once we have a certified model, we can calculate the initial payments and the initial guarantee for this upcoming school year for all school districts, including the amounts that will flow through to the charter schools. But even that will only be an estimate. And the reason for the charter school number being still a little bit in flux is that we start the year off using an estimated enrollment number that the charters provided back in March. We plug that into the funding model to begin the year. And then we are required to update those estimates using the actual enrollment that's provided in October. So we will true everything up in October for the 2 charter schools that we expect to open their doors this year. And then that will ultimately change their total funding for the year based on how many students are enrolled and attending in October. But I will have a placeholder. I'll have a ballpark estimate as soon as we have a certified model. And then we'll have an even better number for you in October.
So to follow up, the 280,000 is for the first year, and then we think there will be 280,000 to be split over the next biennium. And then after that, should we expect that 280,000 to go away and we would be totally dependent upon the this 3%, up to 3% as becoming the funding source for this board? Is that your understanding?
Mr. Chair, the 280,000 actually remains as part of our standard budget. So there's language in that footnote that basically indicates that $280,000 becomes our standard budget, but that the intent of the legislature is for it to remain at that sustained level. So basically, they didn't want it to double since we were getting the same amount for the first year. Without that language, you might expect it to biennialize or double for 2 years. And so they didn't want it to double, but it will remain in there in the standard budget, absent some kind of legislative action that would modify that going forward. So you could expect that in this next biennium and every biennium thereafter, unless the legislature changes it, or through a request that we put forward, it could be modified with their approval as well.
So the 280 or 140,000 per year looks to me to be your estimate of approximately the cost of a full-time equivalent with benefits. Is that roughly right?
Yeah, Mr. Chair, that's pretty close. We were at about $130,000 for the salary and benefits for the position per year. Now, of course, we don't have all of the final details yet on the benefit side. Health insurance elections and those types of things could change that. But whenever we put together an estimate, we calculate the number based on if someone selects like the family health insurance plan, the most expensive option, we would need to have the money to cover that. And so anything other than the family would save us a little bit of money. And we'll see how that all shakes out. But yeah, that's close. 130,000 is our estimate for the position.
So Janine has a question for you, and then Cindy.
So Trent, we had a discussion earlier on, I don't know if you were listening or not, where there was discussion about ADM. So when you're making these calculations, so let's say we have the 3 schools, 2 opening this fall, right? I would suggest there's a significant difference in the per ADM cost between the Natrona County School and the Chugwater School. So are you using, for example, the cost of an ADM in Natrona County to calculate the Natrona County School and the cost of an ADM in Chugwater to calculate the Chugwater School?
Yeah, Mr. Chair, thank you for that question. The way that the model will calculate that funding is based on the specific inputs that are for the charter school. So it would vary by district. And it would be dependent on a whole lot of different factors. But it doesn't actually look at the district. See if I can explain this in an easy way. It doesn't necessarily take the district per pupil funding amount and just multiply it across. It looks at the specific demographics of the school. So as you might be aware, there are differences in funding for, say, a small school. A small school, less than 49 students would receive additional funding in different categories. So it depends on the size of the school, but the school essentially is funded just like any other school would be in the model, with the exception that for the first 3 years, we basically use a different method of rather than the typical average daily membership input that drives most of the funding. For the first year, we use this March estimate followed by a true up with the actual enrollment. And then for the second year, we use the prior year and true that up with the October enrollment again. So it's following almost more of an enrollment type of a method rather than an average daily membership. So that is one difference, but otherwise the way that the funding is calculated in the model is very similar to any other school, and it uses the same ratios, et cetera. Does that answer your question?
Kind of, thank you.
Cindy, you had a question?
Thank you, Mr. Chairman. Yeah, I actually have two, with your permission, Mr. Chairman. The first one is the job description for this position available yet, or has that been created? And do we, as a board, have any input on the creation of that job description? Was my first question. And then my second question is kind of knowing where we're at on some of this. And if I'm on the wrong track, please get me corrected on this, but I'm very hesitant to see a 3% administrative cost come to the operation of this board as opposed to being in the classroom of these schools that are trying to get going. Like that to me feels, I mean, if this is money that can't go to the classroom or something, then that maybe is a different conversation, but I'm very hesitant to divert 3% away from these schools that are trying to get off the ground for the funding of this board.
And maybe that was the reason for 280 being allocated separately. And that may be, unfortunately, borne disproportionately by the folks we just gave the deferral to. But I understand your question. The first question then is about the position. And Trent, are you the one to answer that question, or should we refer that to someone else?
Yeah, Mr. Chair, I can start, and then maybe Elaine can add a little bit to it. But my understanding is that we have already completed the recruitment process for that position, and we are nearing the finish line. Made a selection already, and are basically ready to extend an offer here very soon. Elaine, is there anything else you would want to add with regard to the position description?
Yes, Mr. Chairman, would you describe it again as what the responsibilities will be?
Mr. Chair, I think I don't have that in front of me, but I can certainly get that.
Others with questions about the job description of what essentially will be our staff person? Yeah.
Mr. Chairman, this goes back to a conversation I had with you just a day or so ago. Is this a person going to be considered an executive director of this board, or what are they considered? What's the job description by name and title?
Mr. Chair, I believe it's a charter school consultant, and it'll be an employee of the WDE. Charter school consultant.
So we will not have an executive director other than the liaison, is that correct?
That's my understanding, Mr. Chair.
And is any of your salary being allocated to this board? Elaine, I'm speaking to you specifically. Yeah. Do you know? Maybe you don't know.
Mr. Chair, I defer that to Trent, because I.
Yeah, Mr. Chairman, I can jump in on that one. So yes, some of the basically when we put together this request, we included an amount for reclassification, knowing that this would be an additional amount of work for an existing WD employee and team. And then, so there is an amount in there for that. And then the new position would be entirely funded from this appropriation. So a small amount for a reclassification request and the entirety of the new position.
Let me ask one other question. What about, are we being charged for a website or phones or things of that sort that are going to be ongoing in addition to the initial setup? And maybe one of you can answer that, Elaine.
Yeah, Mr. Chairman, I can jump in on that. So we did put together an estimate for board member phones and equipment. Of course, we didn't know what that would look like going into the session, but we did estimate $3,600 for board member phones or equipment if that's something that's needed.
Mr. Chairman, I'm getting more lost. What do we need a charter school consultant for? I'm not trying to be smarty. I'm just saying, what are we going to need that for? I think the staff responsibilities that I think we're going to need are going to be different than a consultant. But
So correct me if I'm wrong, Trent. Consultant is more a description of the level of a person rather than a description of their job. Is that a fair statement?
Yeah, Mr. Chairman, that is a fair statement. That's kind of just the terminology that the state uses for most of our education positions. But I would say that the actual job duties and responsibilities, we have some latitude there in what that would look like. And my understanding is that really the intent is to provide full support to the board and anything that you need with that position. So I'm not sure, consultant is the label that the state uses for those position classifications, but really it's the support for the board. That's what that position is provided for.
Joe, go ahead.
Mr. Chairman, if I may, as I see it right now, I mean, the next couple of months, I see that as far as the consultant's concerned, not too much involved there. But what I'm really concerned as a former educator, and one of our duties, as I understand it from Mr. Williams, is eventually evaluation of the charter schools. And I'm really concerned about that. And I see a need for a committee and how that's going to be done and how that process. And so in the near future and moving forward, I really see the need, and without looking at the job descriptions, but I hope that's part of it, in assisting us with the evaluation of charter schools when the time comes. Otherwise, I have a feeling that it just will be overwhelming for this board to go through and sort through individual data from schools. And so, again, reiterate myself, coming out of the chutes here, I think we're doing fairly good for the first meeting, and maybe here in the next 6 months, there may not be much as far as, but in the future, a need for somebody. I think it's definitely needed. And I'm with you to some extent. Seems like a lot of money and so forth, but I think we have a huge responsibility, and one piece will certainly be evaluation. And I'm personally concerned with that, being involved with a lot of evaluations in schools over the years.
Fred, I think you had a question or comment?
Thank you, Mr. Chair. So I'm on the same page. And so in that position description, was it somebody with expertise or experience with charter schools? Do we know? Without getting into the details of the job description.
Mr. Chairman, I don't have that job description in front of me. I wasn't involved directly in the hiring, but we could certainly provide that to the board. I believe it was posted publicly, so there wouldn't be any issue with that.
Can we modify that if we so choose after it's been posted? Or would we have to go through the recruitment process again?
So Mr. Chair, as long as the scope of responsibility is still within the same realm, we do have latitude to make changes to a JCQ after a position is filled. Imagine that we're still talking about support for the board and a lot of work related to charter schools. So I don't think we would be too far off the mark from where we started. But if we needed to delineate anything, I think that's a conversation that could probably happen with Elaine and with others at the WDE.
Well, it seems to me at a minimum, we need somebody that has some understanding of assessment and growth and the state process. We also need somebody that can monitor the compliance with the requirements of the charter contract and report to us any non-compliance, and somebody who's willing to travel, because I think this is largely on-site type work. And I don't know if that's included within the description or not. And I guess I would be loath to hire somebody and then change the ballgame on them dramatically.
Mr. Chairman, and I'm not looking for a fight, but I think we need to draw the line in the sand. We're being force-fed an employee that we don't even know what their skills are, what their job description is going to be, without us having any input. I think we should be the one deciding what we need and then asking them to find that person for us. It looks like to me the process is completely in reverse.
Other comments? Fred?
I don't disagree, but I also recognize the need for expediency. So it'd be real interesting if we can get a copy of that job description and the person that we're looking at, because if it's the right person, we can move fast. But if we have some concerns, maybe we need to have a team back somehow, or a selection committee.
So I could be way out in left field, but it looks to me like these charters will really not have anything for us to review for a period of time. They'll need to get up and running and operating. And so I don't see the urgency to fill this position immediately, other than, as Fred said, if there's the right person and we need to tie that person down. But what is, oh, Mitch, go ahead.
The thought that I keep having is the charter schools that have been approved and are ongoing, I think, we have our liaison between us and the Department of Ed, but where's the school's liaison to us? And I think that's kind of that role, right? So that they have somebody that they can reach out to, rely on throughout this whole process. When we're only meeting so often, they're going to need somebody there that can be that person in between with us. So I can see that immediate need right now so they have someone for some support from the state, from our board. So I see that. Now, Brandon, I don't disagree on, I haven't seen job description, so I don't really have anything to add on that part, but I do know that the Department of Education understands education. So I'm gonna put a lot of trust in them on that side of things, and especially when in the realm of charter schools. So that piece.
Well,
Go ahead, Doug.
if I could follow up on that, Mitch, and I respect what you said, but if I understood what Trent said, it's already a done deal. They're ready to close the deal with somebody that we don't even know who it is. And, I'm not in favor of having someone communicating back and forth with the charter school, and we don't even know them. We didn't have anything to do with selecting them. We're a brand new board. And I understand what you're saying, Fred, about expediency, but also haste makes waste sometimes.
Mr. Chairman, just listening to the conversation here, I just wonder if I could ask Mr. Carroll if there's a way to, if we could pump the brakes a little bit here, not that we want to completely, go back to square one, but perhaps maybe we can have a little bit more of a conversation or improve our understanding of what the job description is, the qualifications of their top applicant, because, I, like Mitch, I agree with what you're saying, that there's a lot of expertise in this area that we're going to want to rely upon. But at the same time, I think really the spirit of this entire exercise is one grounded in collaboration. And so if there was a way to maybe pump the brakes a little bit to kind of get past some of the concerns maybe that you've heard today, is that a possibility, Trent, or are we kind of beyond that point at this time?
So let me interject first. I think we have a need for a meeting in the near future, and maybe in the next couple of weeks even. So with that in mind, Trent, are we, and McKinsey has his hand up too, but I want to pose this to Trent. Could we put things on hold for a couple of weeks without derailing your process?
So, Mr. Chairman, that's something that I would definitely want to talk to the superintendent about before giving you an answer on that. I certainly respect the comments from the board on this. This is not completely uncommon situation where, we provide staffing and support to the State Board of Education, for example, with WDE positions. The State Board of Education's budget is part of the WDE's budget. And so we've run into some of these things before, so I'm familiar with it. I'd be interested to hear what Mackenzie might have to say, but for the time being, I can certainly bring the concerns to the superintendent and to the chief of staff, and we could get back to you directly.
Mackenzie, you had something?
Mr. Chair, I'm afraid Trent took a little wind out of my sails because that's more or less what I was going to say. I do want to clarify so that we have a common understanding of what the roles are here, because the appropriation was part of the Department of Education's budget. And ultimately, this is a department decision. I just want to make sure everybody understands that this is a discussion request. And so everybody's on a common understanding of what the roles are between the board and the department. It really is the department's decision on the degree to which to defer to the board and hear those requests that the board is making. So I just wanted to make sure those lines are clear and that's understood, that these should be taken as requests to the department.
And I think the concern that I hear from the board is we want to make sure that our duties are discharged and not by Mitchell having to go to Chugwater and do them, or Doug going to Casper and doing them. We want to make sure that our duties are discharged. And to understand that, we need to see and approve, or understand at least, the JCQ. I think that's what they're called, right? JCQs, the job description for this position. Doug, you
Mr.
had.
Chairman, for clarification, do I understand that we're given 280,000 and now we're being told how it's going to be spent?
So I think your microphone's not on.
We've been given 280,000 and now we're also being told how it's going to be spent?
I think what McKinsey just said is we weren't given it. It went to the WDE, and they are supposed to staff us with a person from within that money. And our concern is that we get a staff person that does what we need the staff person to do. And I don't think those are incompatible, but I don't know that they're compatible at this time.
That's 100% correct, Mr. Chair. That's exactly what I'm saying. And I'm just trying to make sure that this is framed as a dialogue between the department and the board. That's my main consideration, so that everybody understands kind of where we're positioned.
So at some point, this may change, but while we have 3 and possibly 4 charters to monitor and to make sure they're complying and that their kids are growing, the legislature at least has given money to the department for that, not to us. And then at some point, this board, can take I'll call it a surcharge on these schools of up to 3% and do something maybe that's similar. And I think I agree with others that that's money coming out of the educational benefits to those children. So we need to be very careful on what that looks like and who handles that and what the budget is and whether we want 1 person or 5 people to be hired for that. But we're not at that point right now, I think, is where everybody is. Now, am I missing the boat?
Mr. Chairman, I certainly appreciate the concern, but I think we have a lot of work to do. And my short experience on the board and with RIDE, we've been given some really good resources. And quite frankly, if we have a resource that's interested in supporting the charter board, if we had to start over, it may take us quite a while to get somebody else. So I am not that worried about it based on my experience.
Joe?
And if I could, Mr. Chairman, usually I know what side I'm on the fence. I am, pretty quick, but I'm sitting on the fence here. And so I certainly appreciate all the points that have been made. It would have been nice to see a job description, but I guess where I'm going to default, or what side of the fence I'm going to get on here, is that, I've worked with the WD many, many years. And so I'm going to put some faith in that you're using good judgment to get the best person. And I'm sure that's difficult and to go through that to meet our needs. And I think if we want to come out of here, out of the chute, with a good buck here and a good impression on the public and doing what's right by the students of Wyoming is that we try and move forward and get the ball rolling, so to speak. And if it means, I think the Department of Ed is open to, if we want to look at the job description and have a little bit of input and maybe refine it some or have some suggestions, I would imagine that they were not opposed to that, if I'm correct on that.
Mr. Chairman, that was nothing but discussion. I didn't mean to bring it up that long, but I move that we set our next meeting date and adjourn.
Yeah, we're at our time. The motion is to set a meeting and adjourn, which is in order, does not require a second. I hope people have a calendar handy. Yeah, we're all pulling our calendars up. Doug, you have a suggested date?
Oh, that's tough. A Friday date might work better.
Is Friday preferable to, or how do people feel about that? Janine is ambivalent at best.
2 weeks.
That'd be the 18th. 18th.
I might have to call.
Well, we might do this virtually. So maybe that's okay. How does the 18th work for folks? I don't, you have another date you'd like to suggest? Well, what? Well, that's within your. Is the 25th okay, Janine?
I don't know. I honestly don't know. I'm going to Michigan. I know what I have booked. I don't know when I'm going to be driving back.
What if we did it great grammar. What if we did it earlier, like the 14th, which is a Monday, a week from Monday? Let's not do that.
Would the 15th be an option?
Did you say you were traveling the 15th or the 16th?
That week is, guys are, that week is just not going to work. If you want to do the 31st of August, I'm happy to do that. That much prior to that.
I'm out from there till the 8th.
You know what, the other board I'm on now, we have a date.
Well, Janine, it's your schedule. Could you join us? If we have, especially if it's a virtual meeting. Any of these days, are there days that you could or could not join us virtually? Even though you're in Michigan, they have the internet there, don't they? I'm being facetious.
That's just a really bad week for Michigan.
So,
Can we go back to maybe the 28th as a possibility, the 29th,
yeah,
the 30th?
I'm liking the 25th or the 28th. Both of those look good to me.
25th, 28th.
28th is my preference.
Well, the 25th is a Friday and the 28th is a Monday. I'm in the right year. I think I am.
Correct.
How many want to do the 28th?
I'm okay on either, so
28th works for me.
a virtual meeting on the 28th.
Cleans up behind the parade.
Virtual if it has.
Pick a day and.
Okay, let's set 28th at, 1:30 in the afternoon? Is that okay with everyone?
Mr. Chair, I was
McKenzie?
just going to offer a suggestion. For the purposes of the open meetings laws, for a regular meeting may be set by various methods, including rule and also resolution. So I would suggest that the board entertain a resolution to establish a virtual meeting on the particular date and time that you've settled. That would ensure that that meeting is a regular meeting, and you would not have those subject matter restrictions that we had today as far as this being a special meeting.
So what makes it regular? Do we have to have it on the first or the last Monday of each month or each quarter or anything like that?
No, the statute provides various methods for establishing regular meetings, and the one that is available to this board is by resolution. Now, eventually, I might suggest that you set out a meeting schedule for a longer period in advance, so that you set, let's say, a year meeting schedule. But for the purposes of this next meeting, I'm just making this suggestion to release you from the restrictions that you have when you have a special meeting.
This could be called a special meeting, is that right, Mackenzie?
This current meeting that we're in is a
No,
special meeting, but
the next one.
I'm suggesting that you could make the next meeting a regular meeting under the
Oh.
statute.
Okay.
All in favor of the 28th at 1:30 as a regular meeting of this board, say aye.
Aye.
Any opposed, say nay.
I'm abstaining because I can't tell you.
Okay, all right.
Where the phone rings, I'll be there. If not,
Okay,
So just, Mr. Chair,
yes.
did we pass on the staffing consideration?
I don't know that we have a motion before us on that. We were just discussing it as part of Trent's presentation.
I know we want to move forward. I'd have a motion that we move forward.
Okay.
I'll second that.
The motion is made and seconded to allow to consent to the WDE hiring somebody that they have in mind, I guess. Is that what you're? Well, no, we established our next meeting, but we haven't adjourned yet. Any further discussion? Let's, Elaine, can you call the roll for this one?
Mr. Chair, would you just repeat the motion so I know?
To move forward with the staffing consideration as proposed?
Mr. Chamberlain? Ms. Delancey?
Aye.
Mr. Filer?
Aye.
Mr. Masters?
Nay.
Mr. Schwab?
Aye.
Ms. Teske? Mr. Von Aaron's?
Aye.
Okay, the motion passes, and we are well beyond our expected adjournment time. Is there anything else that, I'm sorry, Janine, yes?
I would like to know what the purpose of it is on the 28th. What are the details we're trying to unpack?
Okay, so it's a regular meeting, so we'll be able to do whatever we want, as I understand Mr. Williams. And we have at least a couple of things. One is the report from the Parliamentary Procedure Review Group. A second would be, I think, that we would at least review what the job description is for this person that is going to be hired. And if we feel like it needs to be further modified, we can propose a recommendation for modification of that job description. And we also want to discuss whether we're going to have a definition of majority other than quorum, but I think that falls within the rules, people. Anything else?
I think we also, go ahead.
I was going to say, yeah.
We also have an unacted upon agenda item as far as with Claire Vicklin, training from her. Perhaps
Yes.
maybe that's appropriate on the next meeting agenda.
Yes.
Meetings, and as well as a regular board meeting schedule and calendar. And then our email setup, website, technology support, reimbursements, just more training.
Yes, some training, although we do have our email now, and I know that you will assist the people here who have claims for travel.
Correct, Mr. Chair, and if we need to, so you have been given the website and a temporary password, and we can set up individual trainings with Paula to do that, so we don't have to do it at the meeting, and that way you guys can have that sooner than later.
And then I saw that there was also a email concerning a per diem, is that right? per
Correct, Mr.
diem
Chair, that's-
compensation or,
That would be part of your travel reimbursement. And so
so if I didn't travel, I don't get a per diem?
I've got to figure out how that works.
We can have the
I think
next
you-
meeting in Rock Springs.
Okay.
Mr. Chairman, just one more comment on meetings. Not today, not tomorrow, not the next meeting, but I think it'd be beneficial if we can establish some day of the week, whatever that, I mean, just a regular scheduled meeting. I think that's beneficial to the public to know. I think it'd be beneficial to charter schools that on the third Thursday or the
Right.
third Friday, whatever the board determines, and for other people's schedule, obviously, everyone's busy, but you can schedule that out and know that that's coming. And that might be 2 months down the road, but I think that would be beneficial.
And I think we'll
in
take that
My
up.
opinion.
Yeah, we'll take that up at the next meeting.
So with that, Mr. Chairman, I move that we adjourn.
Motion to adjourn. Any, there's no discussion, no need for a second. All in favor, say aye. Any opposed, say nay. Motion passes. We're adjourned. Whew. Made it through the first meeting.
We were going to forget that part.
All right.